Yes, please, Sir. My lord, may I be allowed to call for a record in item number 15 listed before this honorable court?
15.
Yeah.
What record?
My lord, it's a change in the name of one petitioner.
No, you want to call what?
Uh,
IA.
Yeah,
When did you file?
yesterday.
Hearing matter.
Yes, sir.
Has it been numbered, registered?
Yeah.
Okay, try to bring it, but I don't think it will be possible. But bring it.
And my lord, I beg to mention a writ petition for listing, my lord.
Pertaining to which bench?
This-
Bench 4.
Yeah.
Matter of which year?
Matter is 2020.
24. What is the urgency?
It's about the admitted amount, my lord. It has not been listed for long, my lord.
Sorry. Next.
Like,
May I please? My lord, I have filed a writ petition, my lord. May be taken by tomorrow, my lord.
Motion.
Motion.
Motion we can have, no problem.
May it please, Your Lordship. With the consent of the other side, I beg to mention item number 21.
Supplemental.
Yes, Lord.
Yes, what is it?
Lordship, today's difficulty. Next week, any date. Your
You're for whom?
petitioner.
I was the respondent, madam. Next week, in date me.
It is joint.
What is the matter about? What is the matter about?
Cooperative matter, Lordship.
Cooperative matter will not do. What is the subject matter?
Petitioner challenged the inquiry report.
Okay.
Done by
Okay, next week. On a request made on behalf of the petitioner, list after a week. Yes.
Lordship, interim is there.
Don't say after on the request of a petitioner, matter is adjourned. To be listed on today is what, 10th. To be listed on 18th.
Yes, ma'am.
Interim order passed earlier to continue till the next date.
Online.
May please, Your Lordship.
Yes.
I beg to mention item number 17.
17. Yes.
Here, my lord, P.N. Goswami sir will appear in this matter for appeal. Due to some difficulty today.
Taken the consent? Have you taken the consent?
Yes, my lord.
Okay. On a request made on behalf of Sri P.N. Goswami, learned counsel appearing for the APDCL, matter is adjourned to be listed on Tuesday next. It's an old matter.
Yes, my lord. Any day next.
On 17th. 17th.
My lord, two more matters is there, 19 and 20.
Yes.
Consent is taken from the other side, my lord. Here also P.N. Goswami will appear in this matter for appeal. May be listed after puja vacation.
No. These are all matters. All on 17/9.
17, Lordship, there is some difficulty. Can it be on 19th?
You are in which matter?
And 19 and 20.
Okay. On 19th. Okay. Okay, order. PN Goswami for date to the 19/9.
Much okay.
Both the matters, 19 and 20.
Much okay.
Okay.
The matter pertaining to issuance of license, IMFL license number, on license. Page 21, Lordship will find, page 19, it starts at.
Yes, Mr. Chaudhary, instruction.
Lordship, I'll be receiving the instruction today. Lordship may take it up on Friday or next Monday, Lordship.
Next Monday. Okay. Heard Sri S. Sharma, learned counsel for the petitioner, Para. Also heard Sri B. Chaudhary, learned standing counsel, BTC, who however submits that as per the earlier order dated 28/8/2024, instructions have been called for and is likely to be received today, full stop para, are likely to be received within a short time, full stop para. On his request, matter is adjourned to be listed on 16 September. 16 September.
Of life.
My lord, here we have filed the affidavit today itself. Copy will be served to the petitioner.
Served, copy has been served upon you.
We will serve.
Okay. What is your name?
W. Ahmed.
You are for the APDCL.
APDCL, man.
Sri W. Ahmed, learned counsel appearing for the APDCL, submits that the affidavit in opposition is being filed today. Full stop. Para. List on Monday next. Will you require time to file rejoinder?
My lord.
List after 3 weeks to enable the petitioner to file rejoinder if any.
My praise the Lord. This matter pertains to payment of contractual dues. If our basic legislation amount which was due to us in 2015 have been paid to us in 2021, so we are claiming interest for that period. But if the facts of the case are such that if we are a firm who were supplying Ayurvedic medicines during the period of 1995 to 1997,
No, your claim is only on the interest.
only on the interest.
Is there a stipulation in the contract for payment of interest?
Lordship, the Act states, Lordship, the interest on delayed payment to small scale undertakings and as well as the Industrial Facilitation Council in their award.
What is your status? Who are you?
Lordship, I am the proprietor of the firm,
It's a small scale industry.
small scale industry. Lordship, the Industries Facilitation Council award was there for payment of the principal amount along with
Yes,
interest.
Mr. Gogoi?
Well, the issue is this, my lord, that facilitation council, they passed an award. For non-payment of the said amount, my lord, the writ petition was preferred before this honorable court. Writ petition was disposed of. Then also, my lord, my award was not paid, including the interest. Contempt was preferred. And this honorable court, in fact, lordship at one point of time had the opportunity to, my lord, vote for that contempt case. I directed us to both the parties to sit together and to form a committee and to decide on that part.
Okay.
Committee was constituted. And my lord, some 34 lakhs was, my lord, decided that will be paid including the interest and all. Petitioner agreed. That was placed before the honorable court. Amount we have deposited in the registry, my lord. Petitioner collected it. Contempt closed. Now, my lord, again, my lord, they have submitted a list stating that another
Your Lordship
78
will kindly produce your Lordship the order at page 41. Your Lordship had directed the two departments because the issue was between the two departments as to who will pay the amount. So your Lordship had
Page
directed
40?
page 41, Lordship. 15/10/2020.
Yes.
Page 41, Lordship. If your Lordship kindly comes to the third paragraph. May I read it? Lordship?
Yes.
This court has upheld the award and non-payment of the same has given rise to the contempt petition, which was instituted in the year 2016. The respondent number 2, who is an officer of the health department, has taken a stand that the amount in question was released to the ASIDC. However, the respondent number 1, who is an officer of ASIDC, submits that the amount has not been received. Pursuant to an order of this court, a part of the amount has been deposited in the registry of this court, but due to the issue raised regarding non-receipt of the amount by the ASIDC, the release of the amount to the petitioner is being registered by the respondents. Now, your Lordship will kindly come to the next paragraph. Considering that this case is pending since the year 2016, this court is of the opinion that the same can be sorted out in a parley between the two departments.
Yes.
So your Lordship had directed the two departments as to who will pay.
No, read further. In
Lordship.
which?
Lordship, it is needless to say that the endeavor of the party
No, in which?
in which the petitioner of a representative may also be allowed to participate. Yes, Lordship. We had participated in the meeting. Now they are relying upon the minutes of the meeting. That is at page 44. Page 44 is the minute. The stand of the respondents is that, Lordship, by this minute we had
40?
page 44. Minutes dated 21/12/2020.
Yes.
Lordship, the stand of the respondents is that by this minute, we had accepted that their request not to claim further interest. Now, your Lordship will kindly come to the paragraph 4 down below. May I read it, Lordship? The members present in the meeting requested to the proprietor, that is the petitioner here in Lordship, requested to the proprietor of MS Hawks Laboratory not to claim further interest in the future. The meeting ended with a vote of thanks. So, Lordship, they contend that since I have put my signature on this minute, hence I have accepted this request. Now, Lordship, it only ended with a request. And the fact that they had requested us not to claim further interest itself shows that we are entitled to the same. Now, there is nothing on record to show that this request was accepted by us. Now, the fact that we are not disputing the fact that we had not put our signature. We had put our signature so that we were present in the meeting. But there is nothing in the minute which shows that this request was accepted. It only ended that the members present in the meeting requested to the proprietor. there is no acceptance here. Now, and their entire stand in the affidavit in opposition is this request was accepted. Now, there is no acceptance. That
This is
the
of which date?
Lordship 21/12/2020, Lordship.
Where is the averment in your petition regarding this meeting?
Lordship.
Where is the averment in your petition regarding this
No,
meeting?
Lordship, this they have brought on their in their affidavit, they have stated
Writ petition is of which year? 22.
22, Lordship.
Where is the averment in the writ petition?
No, Lordship, this statement, this meeting, minutes of meeting, were already considered in the contempt petition, and we have enforced the order of the contempt petition. That,
No, where is the averment that there was a parley in terms of the,
Lordship, we have annexed the contempt order, Lordship. Where is
not
this,
the, we are asking for a statement. We are not even asking for the document.
Lordship?
Where is the averment? Pleadings. Is there a candid disclosure from your part?
Lordship?
Is there a candid disclosure from your part in a court of equity?
No, Lordship, because this minutes, we have annexed the contempt order, there was a request, so we have, that was a request and.
You are developing your case on the basis of a document which they have annexed in the affidavit in opposition. This document is of the year 2020.
No.
Where your signature appears. We are not on the aspect whether your signature will bind you.
Right.
But where is the statement that
No.
you had participated?
Lordship, our case is that, that amount due to us in 2015 have been paid to us in 2021.
Council, you are going on a different direction. Is there a statement?
Lordship, that specific statement is not there in the.
Even a cursory remark, something, even a hint of that there was a meeting? Anything? Nothing?
That specific statement is not here, Lordship.
You have not been candid to a writ court. There is no candid disclosure of facts. You state the facts, make out a case, take out an order.
Lordship, this is an admitted fact that they have paid that amount pursuant to this minutes. That we have stated that they have deposited this amount pursuant to the minutes.
Where is the statement?
Lordship,
We're asking you that where is the statement that there was a minute meeting on 21/12/2020 where you had participated, you were given an onerous clause, you did not accept.
Lordship will
This is
kindly.
not a defense which has been now set up by them. This was an existing fact. It's not that you came to know about a meeting only on getting the affidavit.
No, Lordship, they said that by this minutes we have accepted their content.
That is it what we're saying.
Lordship.
Is that only on getting the affidavit in opposition you came to know there was a minute submitting?
No, Lordship, minutes was
So-
there. We are not disputing that. But the fact is, Lordship, there was no acceptance to that minute. Because their stand is by this signature, we have accepted the request made by them. Now, Lordship, in the minutes, there is no request to there is no acceptance of that request. Now, mere signing of the minutes, Lordship. If your Lordship may.
How do we deduct the, even if we admit, assume that you are entitled to interest, how much would be the interest?
But if the interest, as per that, we have made a calculation, Lordship, as per the interest on delayed payments to small scale and ancillary industrial undertaking at 23. Lordship, the amount as on 2021 stands at, Lordship, the balance amount stands at 70,54,754.
How much is the interest?
Lordship,
Interest?
Lordship, there is a, if your Lordship may kindly take.
No, how much is the rate of interest?
Lordship, the rate of interest varies as per the act, Lordship, as per each and every year, Lordship. The more it gets delayed, the
So,
increases.
who will prove this? How do you prove this?
Lordship, we had, Lordship, after the closure of the contempt, we had also preferred a representation to them in 2022.
Now,
Yes.
how does the writ court determine the interest? How much would be the rate?
Lordship, in their affidavit, Lordship, they have only disputed on the fact that that signature denies, means acceptance. They have nowhere.
How much would be the interest? Can we assess it?
Lordship, as per
Mr.
the act,
Chakraborty, why don't you answer the court question?
Lordship, as per the act,
We ask a question, you answer the question, that is all.
Lordship. Lordship. Lordship, the act specifies the
Yes.
interest amount, Lordship.
Yes, how much? That's all. Delayed payment side, interest on delayed payment. Show him the act. No, we have the act. Interest on delayed payment. এখন আরো আছে তো আমার ইন্টারেস্ট ডিলিট পেমেন্ট করবো একটা এখন Yes, which
Lordship, will
provision?
kindly come to section 4, Lordship.
Yes, please.
Date from which and the rate at which interest is payable. Section 4, Lordship.
Yes.
Date from which and the rate at which interest is payable. Where any buyer fails to make payment of the amount to the supplier as required under section 3, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law in any law for the time being in force, be liable to pay interest to the supplier on that amount from the appointed day or as the case may be from the day immediately following the date agreed upon, at such rate which is 5% points above the floor rate for comparable lending. Explanation: for the purpose of this section, floor rate for comparable lending means the highest of the minimum lending rate. Charged
You
by
are
the-
reading an old act. Your act is of which amendment is of which year?
1993, Lord.
98, there is an amendment. 98, there is an amendment. You're having an old act.
Lordship,
There's a change in this in 98.
Lordship will give me a day's time then to get a copy of the new act because
Mr. Yes, what do you say?
My lord, the principal amount is 1,75,000. Now we have already paid about 39 lakh. If this goes after all public money, my lord, he will have to show how he is paid it. For 1,75,000, 39 lakhs have been paid to him.
I am prejudiced by the fact that
Just because, my lord, there is a provision in the act, my lord, regarding the interest part. Can he keep on, my lord, claiming it? After all public money, that part will have to be seen, my lord. On a-
Principal is 1 lakh?
1,75,000. I am giving it. 494.
4?
490. 1,75,490. And my lord, lordship may also see page 42,
And how much have you paid?
about my lord 39 lakhs. 39 lakhs 92,941.
Lordship will kindly consider that this supply was in
Page
91st.
46. Page 46 for a moment, my lord, of the affidavit, part of the affidavit.
When was the supply made?
Sometimes in 1995.
1995. Payment made in 2021.
This 39 lakhs odd is inclusive of interest or what?
Yes, my lord. Principal amount was, my lord, already paid, I suppose, my lord.
Lordship, the amount,
Only the interest was there.
So what is the extra interest they are claiming now?
My lord, in the writ petition, it is
This-
some 70 lakhs.
No, no, what is the interest? Under what provision? Yeah, what was the interest which you have paid?
Yes, yes. Sir. But that part will come under that, my lord, the act, my lord. Which has now been repealed.
the amount which they have paid to us, Lordship, that was due to us on 31st of January 2015. 39 lakhs 92,941. That has been paid to us in 2021. We are claiming interest for this payment which was made to us after 6 years. The amount due to us in 2015.
Well, the act which has been mentioned in the, my lord, court's order, the page 20, it is the MSME Act. Because the earlier act was, my lord, repealed. In 2006, the MSME came in.
Okay, let him have a day's time. We'll have it day after tomorrow.
Lordship.
There's an amendment of 98. The rate of interest has changed, but your submission, there'll be no substantive difference in the submission, but have a look at the new act.
Lordship.
Okay. On the request of Sri T. Chakraborty,
A. Chakraborty.
A. Chakraborty, learned counsel for the petitioner. Matter is adjourned to be listed day after tomorrow.
Obliged.
I am obliged.
You see on the part whether read court can determine interest.
My lord.
If at all he may be entitled to interest, what will be which should be the forum?
Sure.
First, whether it will be entitled.
Sure.
Equity court, all this, okay, yes, next. I will go to it. Contact it with you. 4 to 8, what are these matters?
Lordship. Lordship, regarding Lordship, NIT was issued Lordship by the respondent and this petitioner was
Which respondent for?
for the veterinary
Okay.
director Lordship.
Okay,
And there were two order Lordship to record was called for Lordship.
private respondent. Okay, what had happened, Mr. Kolita?
Lordship,
NIT was there.
Lordship, NIT was issued Lordship according to this petitioner participated
NIT of which year?
Lordship
Date?
2023. Which petition? Five petition.
You are having which record? 1069?
In all 5 cases.
No, we are taking a one
Yes,
record.
1069.
Okay. NIT was NIT for?
Lordship for construction of some Assam type building Lordship for veterinary
Work contract,
work contract. Lordship.
not supply.
Not supply, work contract. Starting with page 15 is the Lordship NIT. It was issued on 6th of April 23.
6th of April, NIT.
23.
Page?
Page Lordship 15 and date is
Yes.
at 16.
Okay.
Thereafter, Lordship, as per the NIT breach documents, Lordship,
Hmm.
there was a clause. Lordship, you find that clause at page 19, Lordship,
Yes,
clause G.
yes.
The
19.
Yes, Lordship, last second Lordship of page 19. Clause G,
Clause G.
Lordship. Qualification criteria,
Yes.
Lordship. The bidder who quotes the rate equivalent to beyond 50% below the current DSI should submit the justification of quoting the rate in details with proper rate analysis along with photographic evidence which their bid and bid process management committee has the right to reject the bid if his justification are found incorrect after physical verification. So Lordship, the some basic issue Lordship involved in this case is if the person who bids beyond the 15%, he has to submit a justification report
No.
to justify the rate of
Okay.
interest.
Hmm.
Thereafter, Lordship, this petitioner was Lordship not to submit justification because he didn't file beyond 15%.
Okay.
So his case was there. This respondent number 5.
Your bid was not beyond 15%. It
Yes.
was within
Within
15%.
15%. So thereafter, the justification report was submitted by respondent number 5. Along with
His
the
bid was beyond 15%.
Yes, it was Lordship, beyond Lordship, 21.5%. So he Lordship, along with the justification report, submitted a quotation. Lordship will find the quotation at page 22.
Twenty-two.
Lordship.
What is the stage now?
Now, Lordship, there was a stay order, but even after passing the stay order, they have submitted an affidavit stating that despite the stay order, the respondent government authorities have Lordship released the Lordship running bill. Showing that
This
some
is-
construction is going.
The interim order is on, saying what?
Saying that Lordship not to proceed further, Lordship.
Not to proceed further. Okay.
And therefore, Lordship, on last 2 occasions, this honorable court directed to produce the record, how they have released that running bill. That has to be Lordship, they produced it.
Okay, 22, what is there?
22
22?
is the Lordship
I'm
quotation.
just indicating one thing, Lord. The work order was given on 6/1/24. The work started. The interim order was passed in the month of March, 6th of March. By this time, some portion of work has been done. That in our affidavit we have stated. After the honorable court order, the work was stopped. And the work is, as on today, is at that stage.
After interim order, Lordship, how they can release, that has to be justified, Lordship.
No, that record I have.
That has to
I'll-
be
I'll-
justified,
I'll-
Lordship, how they can release after stay order.
That is, I have the
Yes.
record and that is. not
Okay,
the-
now we'll come to you, Mr.
Lord.
Datta. Okay.
I have the record, but that is not.
Then
the-
also
not
we
the
find
petition.
page 22 is the quotation.
Of
Yes,
R,
20.
of R5.
Lordship, R5. So Lordship, to justify his Lordship rate of Lordship the materials, he
Yes.
has submitted a quotation
Hmm.
showing that my enterprise. In the my enterprise, Lordship will find,
R5 is my enterprise.
yes, Lordship, my enterprise. My enterprise, Lordship, they have, their contention is that my enterprise will supply them the goods on the below rated quoted rates, Lordship.
Just
Lordship
a
will find there-
just a minute, please. No, R5 is on Bobita Bora.
Yes. Bobita Bora R5.
No, Ma Enterprise is not Bobita Bora.
No, Mahanta is not Bobita Bora. Bobita Bora has lordship substantiated her justification showing that this Mahanta will supply her materials on its so and so rate. So she can lordship perform the work contract beyond 15%. That is her justification.
Okay,
So the lordship will find the second line Mahanta price. There is a GST number.
yes.
There is a GST number. So lordship accordingly on the basis of this quotation and justification report, the respondent number has lordship got the work order. Thereafter, lordship, this petitioner found that the GST number mentioned in the quotation doesn't belong to this Ma Enterprise. That in Excel lordship I have got annex. Lordship will find at page 41.
41.
Lot. This GST number belongs to some Sanjit Gupta. Page 41 annex A6. This is not disputed by the lordship respondent also. This GST number belongs to Sanjit Gupta.
Yes.
Lordship. So on the basis of this lordship false and false document, the respondent number 5 lordship would appeal to lordship obtain the work order. Accordingly, this petitioner approached this honorable court on first 2 days lordship. This honorable court lordship asked them to take their instruction, but they failed. Being failed lordship, this honorable court stayed the matter. After lordship,
The 6/3/2024.
yes, matter was stayed not to proceed further.
Hmm.
Thereafter lordship, there are 5 cases, 4, 5, 6, 7, and 5. In all cases, lordship, I'll go one by one. In all cases, this quotation is same. Everything is same. Thereafter, lordship,
And the respondent is the same.
respondent are this one is Bobita and other two are 2 different persons.
Okay.
So now
Now there are how many cases total?
I have filed 5 cases, lordship.
5,
4, 5, 6, and 7.
5
Yes.
cases. And the respondent, private respondent are different in all the 5 cases.
In 2 cases same and 1 is different. Lordship. Total 5. In 5 and 6, 7 and 8, they are different. 2%, and in this one is different. Bobita. 2 is Hemanto Bora and Diganto Bora, and 3 are Bobita. They are lots of family members. All are family members. Same family. Lordship. Now, lordship, will also see the work order that I have annexed.
But the quotation is all from Ma Enterprise.
All yes, all quotation My Enterprise. Everything is same except the name. Now, lordship,
Name means name of the.
yeah, like lordship, here it is approached to some Diganto Bora, Bobita Bora.
Understood. Understood.
Everything is same. And work order, lordship, it was published in the website. Lordship will find at page 40. It was published on lordship 13/2/2024. And I will also come that point also, lordship. In other cases, they themselves have stated it was published.
Where do you?
Last lordship signature not verified, 13/2/24. Page number lordship 40, the work order.
Yes.
Now, respondent number 1 to 4 has lordship filed their affidavit. And in their affidavit, how they have justified lordship will find at page 77 lordship. After work order was allotted lordship, there is a letter lordship approached by the My Enterprise approaching
Page.
lordship 77 of the affidavit of respondent number 1 to 4.
Okay, 10.
77 lordship, it is in my copy lordship, it is mentioned as 77
Yes, it's 102. Doesn't matter. We have got it.
lordship.
Annex 5.
Annexure 5.
Yes, what is this?
So it is written by from Maha Enterprise
Yes.
to Bobita Bora. With reference to the subject cited above, it is to inform you that inadvertently the GST number so and so had been put by the computer person without my knowledge in the quotation dated 22/4/23. In fact, I do not have any GST number against my shop name. So first, had it been a 1, that can be considered that there is a typical mistake. In every 5 page 78 and page 79 also. Page 79, it was a report of junior engineer.
Hmm.
Junior engineer has approached to the executive engineer, animal husbandry and veterinary department, Assam, number so and so, your letter number so and so. In inviting a reference to the subject cited above, I have the honor to inform you that, as directed by you, I have visited the site of stock materials of Bobita Bora, Khanapara, Guwahati 22, against the work construction of sub-center building at Alia in Nalbari district.
No, you are reading page?
Page lossy between page 79.
Okay,
Yeah,
just a
section
minute, just a minute, just a minute. Oh, yes. This is dated
This is dated lossy 19/10/23.
9/10.
Yes. Sorry, 19/23. I have the honor to
This is by junior engineer.
junior engineer.
Hmm.
Stock materials of Bobita Bora Khanapara against the work construction students. Photographs of building materials are enclosed here. He has given a lawsuit report.
Hmm.
Now lawsuit will find the next page.
Hmm.
Next page is also photographic evidence of materials available.
Hmm.
Now, if lawsuit compare the photographic evidence of page 80 in all 5 cases, lawsuit will find the same photograph lawsuit. One thing. Number 2 is that there is no GST tag in the photograph. They could have lawsuit, yes. In photograph lawsuit, basically what happened lawsuit when they work construction of public work, there should be a geotag number. Here nothing has been there lawsuit. They only a lawsuit photograph taken by someone person in 4 cases, same photograph has been annexed. Now lawsuit will find the page 83 progress report. Progress report at page 83 also.
Yes.
Name of work so and so, name of contractor Bobita Bora, work order so and so, bill value 11,41,560. Certified that the aforesaid work has been progressed approximate 70% by the concerned contractor as per approved plan and estimate. So the work order was published on 13/2 and this report was issued on 22/2. Within 7 days, lawsuit, a work of 31 lakhs lawsuit has been completed 70%.
11 lakhs.
Yes, no, lawsuit, it is only the running bill amount, not the complete order. Complete order is 31 lakhs.
33 lakhs.
33 lakhs, yes. So lawsuit, within 7 days, they have completed 70%. Now lawsuit, the respondent number 5 has also submitted an affidavit in opposition.
Just a minute, please.
Yes.
When was the junior engineer's visit?
It was on 20th of February, Lord.
Huh?
Progress report of 20th of February.
No, his visit dated.
Visit lawsuit, yes. Now, prior to work order issued, he visited lawsuit at page number 910 lawsuit, 910/23.
Work order is of 6/1.
6. As per the it is 6/1, but
6/1, 6/3, or whatever. 6/3 is the publication date.
yes,
He
13 to publication.
He makes a visit on 9/10/2023.
So prior to issuing lawsuit this work order, he visited and he has given this report. And after work order lawsuit, he again visited and stated that 70% has been completed within 7 days.
Yes.
Now Now, respondent number Lordship 5 has submitted his affidavit in opposition. It is mentioned as page number 51, but the copies are to me.
Right.
In paragraph number 9.
Just a minute, just a minute. 5. Yes.
Lordship. Lordship will find at page 47, paragraph number 7.
Subject. Sorry. And page,
Page 47 Lordship. Running page.
para
Para 7.
7. Yes, please.
I am reading Lordship.
Hmm.
Which regards the statement made in paragraph number 5 of the writ petition, the answering deponent state that in justification quotation dated so and so supplied by supplier proprietor My Enterprise to the deponent, the GST number was inadvertently put by the computer typist, maybe for cut and paste at a hurried manner on the last day of submission. While typographical error was detected, the supplier proprietor clarified and informed the matter to the deponent by letter dated 11/12/23. Accordingly, the deponent informed the matter to the authority concerned. Then the filed letter dated 12/12/23. For that, the deponent should not suffer. However, the authority concerned informed the deponent that as per provision of 2AZ of chapter 4 of the NIT instruction dated 6/4/23, the GST number is not necessary, relevant in quotation justification, except the rate of materials and its availability. Hence, the bid of deponent was accepted after due scrutiny of the document and the quotation dated 22/4/23. So, Lordship, the respondent number 5 has stated that she was informed by the concerned authority that no GST number is necessary. Is there, Lordship, any Lordship notice, Lordship, that to inform all the bidders to know that no GST number is necessary? It was personally informed to the respondent number 5 that no GST number was necessary. Thereafter, Lordship will find at page 51, paragraph number 19.
Let us see the clause of this
Lordship.
6/4/2023 2AG.
Lordship.
Has it been annexed?
Yes, Lordship. Last time I read out, Lordship, in the first time. Okay. At page 19, Lordship. There was no such mention, Lordship.
19.
Page 19, just I have read out, Lordship, the clause G. There is only,
2AG.
yes, clause G, Lordship, just I have read out. Only the bidder who quotes into equivalent to beyond 15% below the current DSR.
No, that you have already.
Yes, already considered. There is nothing mentioned that no GST number is necessary. Now, the official respondent, Lordship, individually informed this respondent number 5 that no
Just
GST
a
number
minute,
is
just a minute. Who posed the equivalent? Yes. Yes.
Now, Lordship will find at page 51. This affidavit was filed on June 24. That is not here, Lordship. It was filed on June. Lordship will find paragraph number 19
Affidavit of
of respondent number 5.
page.
Page, Lordship, 51.
Yes, paragraph.
19, Lordship, the last paragraph. Just I'm reading.
Just a minute. Yes, please.
Lordship. Paragraph number that against the said construction work, the authority concerned verified and prepared the bills amounting to rupees 11,41,506, and after deducting the taxes, the authority released the running bill amounting to so and so by office letter dated 21/5/24.
Hmm.
So this is, Lordship, my grievance, Lordship. Although interim was passed on 3rd of March, they have their own affidavit also stated that it was released on 21st of May. Now I have, Lordship, replied to their affidavit. Lordship will find my affidavit in reply. I have annexed all quotations, Lordship, and clarification report.
Your reply to R5.
R5, Lordship. Lordship will find page number 101.
Reply to R5.
Yes.
Internal page.
109, Lordship.
Yes. What
Lordship.
is-
So Lordship will find page number 109, the quotation. It was issued in the name of Diganta Bora. The next page is, Lordship, the clarification given by my enterprise to Diganta Bora. Next is also same, Lordship, quotation. Everything is, Lordship, the Xerox copy of each other, Lordship. Not a single, Lordship, word is here and there. Everything is same. Then the next page is also clarification. So, Lordship, had it been a one case, Lordship, that can be considered that there's a typical error or copy paste, Lordship, due to hurry. In every 5 cases, Lordship, same quotation, same date, and same justification, same date.
No,
Justification.
no, that may not be a factor. Since
Yes,
it is
Lord.
since it is given by the same enterprise,
Yes,
they may give the justification that we are not too much
Lordship.
concerned.
But all quotation is same date, all clarification in same date.
The work is pertinent to where? Which place? Nalbari?
It was, Lordship, Nalbari. Yes, Nalbari.
4 works. 4 works in total.
Yes, Nalbari, Lordship. Of
All
different
four,
of eight.
all 4 works.
All four.
Total,
Nalbari.
total 8 work. Total 8 work.
I have 7-6, Lordship.
Okay, 6 works are
Six, today, Lordship, 5 matters has been listed, one is not listed.
okay.
five
Five works in Nalbari.
Nalbari, Lordship.
In that case, there is no interim order. And the other work, it is already going on.
All
There is no-
cases interim is there, Lord. So, Lordship, my basic case is that, Lordship, they have fraudulently obtained the work order, suppressing the actual fact and submitting the some first document. First thing. Second thing, Lordship, the official respondent has lost their, Lordship, right to defend the case because they are not, Lordship, complying with the order of the honorable court. They are disrespecting the honorable order, court of the honorable court. So, Lordship, they have already lost their defense. And this official respondent should be, Lordship, personally appear before the honorable court to reply the, Lordship.
Yes.
And in one cases, Lordship,
বেলেগে তো ফাইল চাওঁ আৰু
Lordship will,
Just a minute. Yes, what is going on, Mr. Nath? All family members,
Well,
what is going on?
as regards the family.
Nothing else is required. Nothing else is required.
No, the kindly, if Lordship kindly comes to the minute, but one family member, it is not a case that all family members have participated in the same time.
Doesn't matter.
Kindly see, they are.
Who is the officer?
No, they are businessmen, they are having.
Yes, yes, who is the officer? Let us see what business do you have?
Well,
All
I
the
will-
family members.
well, I'll take your Lordship. I'll take your Lordship.
Who is the
Well-
officer who has given the work?
But after
What is the name of the officer?
a detailed process,
What is the name of the officer?
but the work order has been issued by the director. Lordship has seen the order now.
Yes, yes, name of the director. He has done a fantastic job.
No, I'll take. your Lordship.
Distribution of state largesse, in a
I'll take it.
fantastic manner.
After the tender process, regular tender process, it will start. Huh?
Yes, director will come. He'll explain.
No, let me give me an opportunity. Well, I have the record. Well, let me place my case.
You don't need to produce the record, Mr. Nath.
I have the record. Well,
You don't need to produce the record of matters of this nature.
I have the record. I'll place kindly. Give
It
me an
smacks
opportunity.
malice like anything.
No,
If
kindly,
you open the records, you'll be in difficulty.
no, kindly, no, well, I have the record. Lordship has directed.
We are not on GST and we are not on anything.
Well, there are.
5 family members, 5 different works, same date, same justification. What is going on?
There are.
Is this what is distribution of state legitimacy, fairness, transparency?
Kindly,
We are shouting and shouting. This is how you implement.
kindly allow me to place my case.
Yes, please do.
Well, kindly see, well, what is this case in paragraph number 8? Kindly come to paragraph 8 of this.
Before we had made this, seeking this clarification, we saw the addresses of the private respondents. Alarming.
Well, I'll place.
Yes, please.
Kindly see, well, what is this case in the repetition? Just I'm indicating what is the demand in paragraph 8, 9, and 10. This is his basic demand. Para 8.
You
9.
put your explanation. We have understood his grievance.
I'll-
You just put your explanation.
Well, his
We have seen the clause that if you quote beyond 15%, you need to give justification.
two things, my lord, two things. One is justification and other is that GST number of my enterprise is wrong. We have in our affidavit file, we have shown that the GST number of the supplier is not required. In fact, the clause, my learned friend has taken your lordship to that.
GSTN of the
Of the
person who
of
would
the-
be doing the work, he GSTN may not be necessary.
It is necessary.
If a supplier would have been the bidder, matter would have been different.
My lord, kindly,
Now, a person who is selling this materials, he does not have a GSTN number.
my lord, kindly come to page number 19.
Is it possible to do any trade without a GSTN?
No, for the purpose of
Just
this,
tell us as an officer of the
my
court.
lord, for the purpose of this.
He engages in the selling of rods, cements. He does not have a GST.
No, my lord, kindly see the GST number of the contractor we have sought. Kindly see page 19. What is
We
the
know
clause of the tender?
contractor's GSTN is not material. He procures materials from another party.
My lord,
That party gives justification.
my lord, while submitting.
Why does he need to give somebody else's justification? Put your justification. I have quoted from this. He does not have a GSTN number. This is very
My lord, kindly come to page 19.
19.
This is the section 4. This is a document. This is a part of the tender document and it is annexed by the petitioner.
Yes,
He is
19.
he is referring to clause Z
Yes.
and kindly come to D serial number 1, Roman 1, Roman 2.
Yes.
So this is the clause qualification criteria number 2 and bidders to demonstrate that they fulfill the following qualification criteria. under this head, my lord.
Hmm.
Ultimately, Lordship may kindly come to 2A, D, Roman 2.
Yes.
So the bidder has to demonstrate that they fulfill the following criteria. It provides a GST registration certificate with up-to-date challan.
Hmm.
This belongs to the contractor who has submitted the bid. We require that. Lord, kindly,
Mr. Nath, we have that much of minimum intelligence. We know what you need. We are not on this. We are not on the GSTN of the contractor. He gets materials from a particular enterprise who doesn't have a GSTN.
Lord, kindly see the
Admittedly, it's not that I have quoted wrongly. My enterprise says I do not have a GST.
that explanation we have, and it is in our affidavit also we have any.
You need to follow the law while giving contract. You are not supposed to have any other.
And this explanation of all these things, my learned friend has not indicated the dates. But the minutes of the bid evaluation committee meeting was on 13/10/2023, 13th of October. And all these verifications, clarifications, and everything report has been done prior to that. It is on record, my lord. In fact, before your lordship also in the affidavit, it is filed. Kindly
Before
see-
the work order, he makes a in
No,
October.
Before the evaluation,
No,
not work.
no,
order.
before October, in October,
Yes, my lord.
the junior engineer goes, he sees already materials and everything has been gathered.
No.
He takes photographs.
Well, a contractor has, while submitting justification, they have said that because they
Give the chronology of the dates.
yes, I'll give. But kindly allow me to
Work
have
order is of NIT is of 6/4/2023. Correct?
2023.
Yes.
23. But I'll take a lordship to that. My lord.
Yes.
Kindly allow me to read two paragraphs of his petition.
Please,
Lord.
please.
Lord. But paragraph 8, he has said that the GST quoted by that after coming to know about the formal work order uploaded in the website on 13/12/2023, formal work order uploaded in your website, this is possibly some typographical error is there because he said that it is 13/2 according to him. I'll place the correct fact. The petitioner downloaded all the documents submitted by the respondent number 4. Admittedly, after the work order is given, he has collected all the documents. Lord. This is the tender process, Lord. And compared with all the documents submitted by all other bidders, during comparison, the petitioner noticed that the respondent number 5 has submitted one quotation of my enterprise having GST number of so and so, and the said quotation was issued on 22/4/2023. That the petitioner suspected that the said document and they accordingly verified the GST number and he found it is wrong. Then, my lord, kindly come to next para. His case is that respondent number 5 from the conduct of the respondent number 5 who has cheated the respondent authorities by giving a fake quotation clearly shows that the respondent number 5 has violated the general terms and conditions. Now, para 10, he said that the respondent authorities has not properly acted upon during the evaluation of the financial. Well, the GST number of the Ma enterprise and the photographic evidence, this was given by the tenderer in support of her justification that the bidder has quoted a rate which is below 15%, 6.5% below. That is why it is the justification given by the tenderer that the tenderer is in a position to conduct to complete the work by quoting a rate which is below 15%.
Give the chronology of the
yes,
dates. Give the
yes,
chronology. That
yes.
will clarify everything.
But if kindly comes to annexure 2 of our affidavit, this is the minus. This minus indicates the date.
Your affidavit.
Yes, it's annexure 2, page 81. And
Just a minute.
Lord.
You filed on 15th of July.
It was filed on
15 July. Okay. Page.
This is the annexure page 81. Internal page 81. There may be some.
And we'll find it out. Don't worry.
Lord. Affidavit filed by.
Yes, we have got one Anil Chandra Deuri.
1, 2, 3, and 4.
Anil Chandra Deuri.
No, Anil Chandra. Yes, Anil Chandra.
Yes. 81.
Annexure 2. Annexure 1 is the NIT in respect of all the work.
Just a minute, please. 67, 68.
Annexure 1, serial number 1 is the work in question in this question.
Page 81.
Page 81. Can you come to that? financial bid has been
Which one? Which one?
open here, the Nalbari district package number 1. This
Yes.
is package number 1.
This is minute, so this is what? Minute.
This is minutes of the bid project assessment committee meeting for evaluation of bid.
This is dated what?
This is dated 13th first line, 13th day of
13 October.
Yes, 2020, 13th of
13/10/23.
13/10/23.
Okay, please go.
Nalbari district package number 1. This is the
Yes.
Alia.
Yes.
Here, lot you will find Bobita Bora, she has quoted 26,46,000. She is L1, found to be the L1.
Hmm.
Then Opurva Kumar Daka, L2, he has quoted 26,63,000.
Hmm.
Emerlin Associates, they have quoted 27,77,000. And Bolan Roy Meti, the petitioner, he has
Hmm.
quoted 28,65,000. He is L4. In this petition, my lord, L4, he has challenged now L1 without making L2 and L3 party in this petition. That is one of my objection, my lord, I'll raise. Kindly take note of that, Lord. Then, my lord, the minute says, after observation, my lord, this is not the first sitting of the committee. Record is with me, my lord. The committee has said that, prior to that also, after observation, the committee have found that Bobita Bora, so-and-so, Kanapara stood L1 bidder, quoting bid price of rupees so-and-so, that is 21.5% below the DSR 2021. As per suggestion of the bid process management committee meeting held on 15/9/2023, the earlier meeting was on 15/9/2023, the departmental engineer has physically verified the related material, documents of justification of L1, Bobita Bora, and submitted a report with photographic evidence mentioning that he has found the stock materials documents as stated in the justification. So the contractor has some materials readily available with her that she proposes that I will utilize that in the work. After examination of the report, the bid process management committee suggested to recommend the L1 bidder, Bobita Bora, at his own quoted price of rupees 26,46,000, so and so, subject to, they have put a condition that subject to deposit of additional performance guarantee equivalent to 6.50% beyond 15% below, which is beyond 15% below of the contract price, and must submit an undertaking mention that he will execute the work as per departmental specifications of the approved plan and estimate as directed within the stipulated time. Malad, here one more thing Lord will note. He has mentioned that all the family members are here. Malad, none of the family members have participated in this particular contract. All are individual contracts. Kindly see the page 80. Page 80, Malad. All 8 works are there. This is the tender notice, Malad. We are on serial number 1, construction of Assam type sub-center building with electrification, water supply, and sanitary work, etc. at Alia in Nalbari district. All works are in Nalbari district, but different place. 2, 3, all are different. Estimated cost, bid processing, everything is different. So in this tender for Alia, petitioner was L4 and the Bobita Bora, the private respondent was
This
found.
is number what?
This is number package 1 in the NIT number 1.
Alia.
And none of her family members are here in this state. None has submitted any tender, my lord. And my respectful submission, my lord, although the petitioner has now indicated that all family members have gone, but they have quoted price and accordingly they have done it, logic. So this is the process of bid evaluation, and the verification has been done. But I will take, in fact, this is the same minute in respect of the other cases also. Lot you will find, and while taking to the other cases, just indicating for a moment, here, package 1, lot you will see. Kindly see, the original copy we have, package 3, the Emerlin is L1. Hemanto Bora also participated there. He was L2. Bolendra Meti petitioner has also participated in there. He's L2. Then in package 4 also kindly see one Digonto Bora, maybe from the same family member, he is L1. And Bolendra Meti, there also he participated, he is L4. Next page, Malone. Kindly see the next.
Your reading page?
The same minutes.
Okay.
Same minutes. Package number 3, package 4. The evaluation committee has taken decisions going by the package number.
Yes.
In package number 4, kindly see Digonto Bora, he is L1 as per the quoted rate.
Yes.
And there what you will find next page. Serial number 4 is Bolan Roy Medhi, the petitioner, he is L4 again. Well, again in package number 5, Lord, you will find Digonto Bora, he is L1, then Bolan Roy Medhi, he is L3. None of the, I'm just indicating that none of the family members are in the same tender, 2 or 3 family members are there. Then in package 6, kindly see, one Hemanto Kumar Bora, he is L1 and the petitioner is L2. In package number 7 also, Lord, the petitioner, he has participated, he is L4. Next week. So we are concerned with Nalbari district, then comes the Borpeta district, Lord, we are not concerned. Now, Lord, last page will be relevant, Lord, in my respectful submission of this minute.
Yes. Last page.
Last page.
Page
Page number 95.
95.
95.
Yes.
The bid process management committee has finally suggested to upload the minutes of the bid process management committee meeting through website for information out to the bidders. The meeting is concluded with, so this has been uploaded in the website. Now, my lord, this is the GST registration certificate of the contractor for this work, Lord. Page number 96. This is the GST number, Lord. As per tender clause, we need the GST registration of the petitioner, the private bidder. Then next page, kindly see, page number 97, page number 98. This is the details of the proprietor. GSTN number is there. Then, my lord, kindly come to the page number 104. My lord. This is the report of the executive, the junior engineer.
Page 10.
Page 104, annexure 7.
Yes.
Verification report. This verification report has been indicated in the minute. Because as per suggestion of the meeting on 15/9/2023, it is indicated in the minute at page 81.
Just a minute. Page, what was it? Where was it indicated?
This Lordship, kindly come to first 104, page number 104, annexure 7.
That we have seen. No,
Yes.
it has been indicated in the minutes we have seen.
Yes, my lord. At page number 81, after the table, my lord, there is a paragraph. The second sentence, my lord, as per suggestion of the bid process management committee meeting.
81.
Yes, my lord, on 15/9/2023.
Just a minute, please.
Lord,
Yes.
81,
Yes.
the after the table for package number 1, there is a table below, L1, L2, LP, all have been indicated. Then in that paragraph, second sentence, can you see? On 15/9/2023, the departmental engineer has physically verified the related matter, documents of justification of L1 bidder Bobita Bora, and submitted a report with photographic evidence mentioning that he has found the stock materials documents as stated in the justification. They said that they have some materials readily available because they are contractors. They have these materials.
When did he make the visit?
On 9/10/20.
No. 15/9.
No, 15/9 is the meeting.
No,
As
no.
per-
On 15/9, he has verified.
No, my lord. Kindly see, my lord. Let me read this sentence, my lord.
Yes.
As per suggestion of the bid process management committee.
No.
meeting,
Please read the fourth line.
Lordship, this is not the starting line.
Oh, as per suggestion, yes.
As per suggestion of the bid process management committee meeting,
Yes.
dated on 15/9/2023, the departmental engineer has physically verified the related matters, documents of justification of L1 bidder Bobita Bora, and submitted a report with photographic evidence mentioning that he has found the stock materials documents as stated in the justification. So as per meeting decision of the 15/9/23 meeting, my lord, suggestion, he verified and submitted the report on 9/10/2023.
Where is 15/9?
15/9, my lord, I have because this is the ultimate decision. We have annexed this, my lord.
Okay.
15/9.
You have 15/9 in the record?
Yes, we have.
Oh.
So, page 104 is the report of the executive, the junior engineer. Junior engineer has given the report to the executive engineer. And these are the next page is the materials. Those are he found while verifying. But these are the materials. But this is an indication that the person concerned, we want to verify that although the rate is quoted, quality will be maintained and rate has been quoted at below 15%, additional performance security you have taken, and these are the materials for her justification that the bidder is in a position to complete the work, even if she has quoted 21.5% below. Then this is the work order below. This is the work order. Well, this is an work order. It's an online. Nowadays, it's generated online.
Yes, yes,
Signed by director. Date is there. 6/1/2024.
yes.
6/1. My learned friend has indicated there is an order. There is same order has been annexed. Same order has been annexed in the repetition. There he is indicating that it was some seal is there. Verification 13/12, 13/2. It was up. It is not in the records. It was approved. It was approved before 6/1, and ultimately it was on 6.
No, let us assume it is 6/1.
6/1.
I see.
So the work. Then can you see next page? This is the position of the. This is the position. This is the photograph of the work. Status of the work. The junior engineer has verified on 28/2/2024. This is the position of the work. This is a construction of Assam type sub-center building with electrification, water supply, sanitary. So this is the civil construction they have done. On 28/2/2024, this is the position. And next page.
Just of this. Okay. Which page? Sorry, which page?
107.
Next page. Okay.
Next.
Okay. What is there?
After the work order, this is the Assam type sub-center. Assam type sub-center at Alia.
Okay.
And next page, kindly come to page 108. This is the certificate. This is the progress report certificate given by the junior engineer with the photographs in the preceding page. He has indicated the work order, tender value, and
Just
bill value. Date of commencement was 10/1/2024. Nature of bill for this bill value of serial number 5. Nature of bill is the first added.
Progress is 70%.
Lost. He has indicated
As on 22,
as on 28/2.
28/2.
28/2. It was started on 10/1. Date of commencement is at 10/1/2024. It's a civil construction plot. Photograph is there. Electrification, water, and all these facilities that has not been done. Nothing has been done. Only the civil construction, because the working season is there. That they want to utilize it. After March, April, the rainy season comes. Therefore, and one more thing, the work is to be completed within
180 days. 180 days.
Lot.
We have seen that.
Lot.
Okay.
But now from the record, I will show your lordship now. The bills, my lord, as regard, because the petitioner, although it is not pleaded case, but he has alleged that, my lord, violation of the honorable court order is there, because despite stay, money has been.
That we are not too much,
Lord, because the.
because paying the money may not be a violation. Since the interim order was passed on 6/3, and from 6/1/2024, some work might have been done. It would have been better if you had taken leave of the court, but that per se may not be held to be violation.
In fact, I have.
That we are not too much,
I have checked.
we're not going into those.
I have checked the record, my lord.
Hmm.
It was long back past and process. It was sent for the FOC. Ultimately.
No, on that you did not address. You address on the substantive part.
Lord. Lord, in my affidavit, my lord, I kindly come to, my lord, paragraph 6, my lord, at 70.
Your affidavit.
The same affidavit. Lordship, I have indicated the annexure, kindly come to paragraph 6 of them.
Yes. Hmm.
That on oath, my lord, we have indicated that in terms of the NIT dated 6/4/2023, petitioner quoted rupees 28,65,184
Yes.
against a scheduled rate of 33,71,000, which was less than 15% of the scheduled rate.
Hmm.
The respondent number 5 has quoted bid price amounting to rupees 26,46,307, which was less than 21.5% of the scheduled rate as per minutes of the bid process management committee dated 13/10/2023 for evaluation of bid. In package number 1 for the state construction, the respondent number 5 became the L1 bidder and the repetition became the L4 bidder. And on 10/9/2023, the departmental junior physically verified the related matter and document of justification dated so and so and submitted a report with.
10/9 or 9/10.
Well, there is some typographical error.
It should be 9/10.
Yes, well, report we have managed. It has to be 9/10. And photographic evidence mentioning that he has found the stock materials document as stated in justification accordingly, subject to deposit of an additional performance guarantee equivalent to 6.5% beyond 15% below of the contract price, and submit an undertaking mentioning that he will execute the work as per the departmental specification of the approved plan and estimate as directed within the stipulated time. Then, my lord, we have indicated that as per clause 2A. Now I have the entire bid document with me, my lord. Okay. Which is meant for evaluation and qualification criteria as
That we have read 2A, other criteria has not been necessary.
logic. The GST registration, we said that the para 8, no?
Yes. Yeah, that we have already seen.
Logic. The justification quotation dated 26/4/2023 provided by the supplier proprietor of Ma Enterprise to the respondent number 5 that GSTN number was inadvertently included by the computer type. Well, the GSTN number of Ma Enterprise, well, it is the same stand taken because the same Ma Enterprise has given that particular quotation. Well, what we find that the prospective tenderer at that point of time, we find that the tenderer has indicated a source from where he will procure the materials at a lower rate. The petitioner wants to justify it. The tenderer wants to justify that. So that is what we have verified with Ma, but GSTN number according to us as per the tender document, ultimately the GST, we will deduct the GST and the benefit, ultimately the petitioner, the particular tenderer has to have that number. And then the Ma Enterprise, we have asked, they said that it was inadvertently given by them. So had it been a case that we have the Ma Enterprise has taken different stand in different thing, then in my respectful submission would have a different story. Therefore, Lord,
A tenderer who quotes a rate beyond 21%,
15
beyond 15%,
below 15.
beyond 15. That is the expression which we have tried to see whether it's below.
True.
You have used beyond.
True.
We don't know what. The tenderer bidder in his justification says that I'll procure from a particular source.
Ma Enterprise.
You are saying that it is the GST of the bidder which you are interested with. He
As per
should
the-
have a GST registration,
as
the
per the tender-
bidder.
As per the tender.
You are not too much worried or concerned with whether the source has a GST.
Lot.
But can a source supply material without a GST?
Well, I,
Had it been the Ma Enterprise clarification that our number was inadvertently quoted, our number is not this but this. The Ma's clarification that we do not have a GST at all.
they have said,
Is it possible to run a business, even the smallest of the business needs to have a GST?
but I have not in the record.
Did
book-
you make any endeavor to ask him that your source does not have a GST? What do you need to say about it?
But,
How have you procured? Or how are you intending to procure?
but justification, what from the record I find.
No, you are very clear that the primary concern of yours is the GST registration of the bidder, not the source.
No,
But once there is this is an exceptional clause that if your quotation is below 15%, you can still give, but you have to be satisfied with the justification. That is something which you are doing it as a matter of abundant caution, and thereafter also there are certain other clauses which will bind him, that he has to give an undertaking, extra security,
extra performance
a
guarantee.
performance guarantee.
And one more thing,
So these are all caveat, in the nature of caveat, that
to ensure that the work will.
the rate seems to be slightly unreasonable. So let us, whether the rate is a viable rate or not, let us see what are his source.
One source is that some material already she has that material, the tenderer has the material available at Khanapara, which is our place. Our officer went there, found that yes,
All the photographs are the same,
same picture, same material.
same material,
Well,
same photograph.
Materials you have shown, and Lordship has seen also the photograph of the construction.
You
Is
say
it-
that
is it
none of
accompanied-
the other members have quoted very well, but so far as the verification is done, it is of the same material. You have to be consistent. You said that 8 packages, none of the family members have quoted for more than one package. It's very good. But to justify, photographs of the materials are the same.
Well, the materials
He
they have
gives the
shown-
GSTN number without even thinking that somebody will go for verification.
Here in my respectful service, lot will see if number one, the petitioner has come up before this honorable court after the work has been started and executed to an extent. And number two, my lord, he is a L4 bidder. Without making L2 and L3 party, there is
At
no-
least in 2, he is L2. At
But-
least in 2 bids, package number 3 and package number 6 is L2.
but in this case, lord, I'll
At least
I'll
in 2.
I'll go to that. I'll go to that. But in this case, kindly see, without making them party and after.
We have noted what you have stated.
Only.
But
with the
let us assume that you are in package number 3 and package number 6, where is L2. What will happen then?
But the authority, as per the tender process, my submission would be, as per the tender process, they have verified what are the documents available, what are the documents required as per the tender condition. They found and also they have discussed the justification and they have taken additional security so that they can ensure their interest. And accordingly, it was done at L1 bid. And petitioner having.
Your records, Mr. Nath.
Record.
Anything else we have understood your case?
Package number.
Mr. Kolita, take your seat. We'll have your chance. Mr.
Package-
Chetri needs to be heard thereafter.
Well, package number 3 is not unattained. Package number 3 is not filling.
So he is
Package-
not challenged.
No. Emerlin Associates, they got, it is not filling.
In different cases, different representation, excellent.
Emerlin Associates is.
Emerald is not using Mars GSTN. So where is the
No,
question of?
That issue is also a little bit different.
Emerlin Associates is not with this Hemanta Kumar Bora, because Hemanta Kumar Bora is L3 there. Is L2, that is a different thing. And this is the record.
No, these cases which are before us today are all using the successful bidder is using the credentials of Ma.
This package number 3 is different.
3 is not before us today. Is it before us?
Emerlin is different.
No, is it before us today? It's not there.
Emerlin one.
It's not there. So what are the cases before us
Yes.
are all connected with the source
Yes.
of supply of the materials. That
And-
is
and-
my enterprise.
My enterprise
Okay.
and kindly see below paragraph 8, 9 and 10, I have indicated.
Yes, yeah.
The basic case of the petitioner is that a GST number has been wrongly mentioned in the bid document.
Yes.
This is his case, that the GST number has been quoted in the bid document and he verified that GST number is wrong. That doesn't belong to my enterprise.
Yes.
We said that GST number of my enterprise supplier is not material for acquisition of the-
You have
Look.
made it clear.
Yeah. It is not his case that the tenderer has no GST.
Please read paragraph 8, the pleadings again. Paragraph 8, the pleadings,
Eight.
page 8.
To follow that. Para 8.
Yes, please.
After coming to know about the formal work order uploaded in the official website on 13/12/2023, this is not correct. And in fact, 13/2/2024 is also not correct, Lord. It was on 6/1.
No, doesn't matter, yes.
The petitioner downloaded all documents submitted by the respondent number 5 and compared with all the documents submitted by all other bidders. That during comparison, the petitioner noticed that respondent number 5 has submitted one quotation of Ma Enterprise having GST number of so and so, and the said quotation was issued on 22/4/2023. That the petitioner suspected that the said documents and accordingly verified the GST number so and so in its GST official portal. However, in the GST web portal, the said GST number is shown registered against some Dhanjit Gupta having trade name Joy Ma Hardware and Sanitary. That the petitioner left nothing to understand that the respondent number 5 had obtained the work order by cheating the respondent authorities, procuring and manipulating fake documents. So this
It is not his case that the bidder does not have GSTN or given a false GST.
correct.
He has said that his source has given a GST number which is not existing.
The tenderer, the prospective tenderer has, while submitting bid, annexed a document. That document contains the supplier's quotation. That quotation contains the wrong GST. That is his case. But I have black mark. If something is required for the
What are the flags?
But the flags I have indicated the different decisions taken by the
Minutes.
minutes are there, and the decisions as regard the processing of bill, because he was raising that question, and he has on numerous occasions submitted that there is contempt Shomoto that is taken.
Okay, that will take care.
Bid documents are there. I have
That will take care.
and the minutes, the decision, this is on 13/10, prior to 13/10, and the decision office notes are there, which led to issuance of the work order on 6/1/2023. Sorry, 6/1/2020. And the decision was on this is the minutes candidacy on 13th of October 2023. Thereafter, record reveals that letters were issued to the successful bidders, whether they accept the letter before issuance of the letter of acceptance. Their agreement was asked. They agreed. Thereafter, the work order reached. It is not a case that meeting was held on 13th of October 2023.
They agreed means that is their rate. What is there to agree?
Correct.
That's their proposal.
No, because they
No,
said,
you invite offers.
no, a condition was in the minus at page 82, kindly see, additional performance guarantee equivalent to 6.50 of the contract price must be submitted with an undertaking. Those are there. That is why they said that this is the,
Those are part of the.
yeah. So this is the decision. Ultimately, it came
They are aware that their bid is beyond 15%.
L1.
And if it is accepted, you have asked for justification, they have given justification.
Undertaking has to be given,
Okay.
additional performance
Okay.
security, then after completion of all, after more than matlab, almost about 2 months, the work order was given. It is not a case that immediately on the next day of the minor matlab, it was given and matlab, nothing has been done. Matlab, the authority has matlab, taken steps for to ensure that the work is completed and the as per the clauses of the tender document they have done it. Therefore, the grievances at this stage raised by the petitioner in my respectable submission has no merit. And that is without making the L2, L3 without third party and only indicating that all the family members of that is what I have submitted. That if the respondent number 5 in this case and the other respondent in the other cases, they are having GST number, they are having every document, they are doing business and they are participating in a tender process. And that too, it is not a case that there is some fertilization in because 2-3 family members are participating in one contract. They are L1, L2, L3, all of them are there. It is not a case.
Yes, Mr. Chetri.
Yeah, please. Since my learned friend has already argued before Lordship, and I go by his argument, my lord, whatever he says. And here, my lord,
Your R5.
R5, my lord. My lord, as per the bidding documents, Lordship will find first thing, my lord, that is probably it is there.
I have given a entire secret.
No, we have it.
I would like to just reference Lord.
Yes, yes.
That is the clause 11.1. 11.1.
Yes.
Yes. 11.1 says the bid documents submitted by the bidders should be in single envelope and shall comprise the following. My lord, these are the very important this part, my lord, at the time of submitting the bid document. Letter bid as per the forms to ensure. Price bid.
No, we have read this. You are interested in GST registration.
Yes.
You have it.
Self-attested GST.
You have it. No problem with that.
Now, my lord, secondly, this is regarding G. Bidder should demonstrate that they have fulfilled.
Which one clause?
This is clause 2, my lord, A, G, my lord.
2AG. Yes.
Section 4, my lord. Section 4, evaluation and qualification criteria.
Yes. 2AG. Yes.
Lordship. And
Yes.
we are concerned about this G, my lord.
Hmm.
Here, Lordship already came across about all these things, my lord. The bidder who quotes the rate equivalent to beyond 15% below the current DSR should submit the justification of quoting the rate in details with proper rate analysis along with the photographic evidence with their bid and the bid process. Management committee has right to reject the bid if his justifications are found incorrect after physical verification. That is there, madam. Here, it is nowhere said that the supplier must have the GST at the time of supply. And I have also come across to one notification of the government of Assam. The person, the supplier, whose turnover is not exceeding 40 lakh, need not have the registration. The government of Assam this notification.
Let us see. Let us see.
The condition was given, my lord, except the few, my lord, this A, B, C, D.
Any person can exclusive supply of goods. Friends does not even.
And here,
Have you made, put any clarification that your suppliers yearly turnover does not exceed 40 lakhs?
I have come to know, but that.
No, this will be wholly irrelevant. You can, if you rely upon this, you have to put on record the statement
I have.
of accounts of the yearly
This is
income,
my-
yearly turnover.
Yes. This is, I have come to know, my lord, only, my lord, that is below,
You're coming to know will not do.
that part I have just informed before, Lord, my lord. And now, my lord, here, my lord, on the basis of the NIT, my lord,
Yes.
on the basis of NIT, I have submitted my, all these documents, my lord, and when it has been found correct, then accordingly, my lord, it has been, after considering all these bidders in the earlier project, my lord, that has been considered, and accordingly, I have been found L1. There are 4 persons, out of which petitioner was the L4, and accordingly, my lord, on the basis of the instruction and the proposals, whatever it is, my lord, my case has been considered, but before consideration, that observation was made by the authority concerned, that after observation, the committee have found the so-and-so person as, yes. After observation, yes, the committee was found.
Which page are you
Bob-
reading?
In my affidavit, my lord, this is minutes of the meeting, my lord.
Page, you tell us the
In my
page.
page, my lord, 55,
Yes.
somewhere it is not,
No, it's there.
yes. 55, my lord, Annexure 2, my lord. Bobita Bora, L1. After observation, the committee have found that Bobita Bora, Simande for so-and-so, bidder quoting bid rupees so-and-so. That is 26,46,307.11 at the rate of 21.60% below the GST 202. As per the suggestion of Bid Process Management Committee meeting dated 15/9/2023, the department engineer has physically verified the related matter documents of justification of L1 bidder Bobita Bora and submitted a report with photographic evidence mentioning that he has found the stock materials documents as stated in justification. After examination, the report of the Bid Process Committee suggested to recommend the work to L1 bidder Bobita Bora at his own quoted bid price of rupees 20 subject to deposit and additional performance guarantee equivalent to rupees 20% beyond 15% below of the contract price, and must submit the undertaking mentioning that he will execute the work as per the departmental specification of the approved plan and estimate as directed within the stipulated time. This is what, my lord, she has got the tender, my lord, in terms of the minutes of the Bid Process Management Committee, which is never been challenged before this honorable court.
What has not been challenged?
This since on the basis of the minute, I have got the this tender, my lord. I've got this contract, my lord, and that has never been under challenge.
What is the subject matter of challenge?
My lord, this minute, in terms of the minutes, my lord, this petition, respondent number 5. Her bid has been considered and accordingly she has been
So
selected.
what is the subject matter of challenge then? If this is not the
My lord,
subject.
at least this NIT or the minutes of this meeting whereby the respondent number 5 bid has been considered, this proposal has been considered, that has been remained unchallenged. I'm just appraising lordship's all this fact, my lord, and lordship will find at page 61, my lord,
61.
61, my lord.
Yes.
This is my registration certificate. Yes,
That is not a dispute. R5 registration, yes.
and this 11/12/2023, my lord, annexure 4. My lord, when this my enterprise came about the this wrong putting of the wrong GST number, he has immediately corrected and he has written a letter, my lord, to the respondent number 5,
Hmm.
Bobita Bora. With
Hmm.
reference to the subject cited above, it is to inform you that inadvertently the GST number had been put by the computer persons without my knowledge in the quotation dated 22. In fact, I do not have any GST against my shop name. This is for your information. And accordingly, on the basis of that, I have submitted another letter, my lord, informing the authority concerned. That is page 65, my lord. Regarding clarification, my lord, probably I should not go through all these things. May I read out? With reference to the subject matter, we have the honor to inform you that proprietor Ma Enterprise Ilachok Chanchuki, Nalbari Assam, from whom I the understand has submitted quotation dated 22 along with the tender document, has now submitted that he doesn't have GST number against his top name. The GST number 22 was inevitably quoted in the quotation by the computer person without his knowledge. The clarification letter is enclosed here with for ready reference. You are therefore requested to ignore the GST number and consider his clearance later for further fraud. Now, my lord, subsequently, my lord, this tender, the work order was issued on 6/1/2024, my
6/1,
24, my lord, 2024,
page.
page 66, lordship.
Yes.
Bobita Bora, so a reference acceptance order number so dated so. With reference to the subject cited above, I am to inform you that you have signed the agreement for the work as shown below. There is an agreement, my lord, between the authority and the respondent number 5. Construction of Assam type sub-center building with electrification, water supply, and sanitary work, etc. at Alia in Nalbari district. And this my enterprise is also belong to Nalbari district, my lord. The same area, same district, my lord. That is why, my lord, this quotation was obtained from this particular top, my lord, so that it will be easier, my lord. If my work is, had there been the work in Borpetar, then certainly it would have been something else. Now, thereafter, my lord, when the construction was started, my lord, almost on the day of 6th of March 2024, my lord, about 80% at where I have a claim for 80% of work, but afterward, the authority has stated that it is only 70% work. already I have constructed the whole building well. Yes, yes, Assam type building. Assam type house. The construction of Assam type sub-center building with electrification, water supply and sanitary, etc. This electrification, water supply, sanitary still work, yet to work, madam. And my lord, on the day of passing the order, thereafter, my lord, the whole construction work has been stopped because of the honorable court. Still, my lord, the work is remain without any execution, my lord. Yeah, my lord, since in the case, my lord, the respondent number 5, as per the tender notice, who have submitted our documents, having been qualified, who have been selected. That is nothing. Only he was confined to the GSTN number. In the writ petition, whole writ petition I have gone through, well, he was confined to the GSTN number. And GSTN number, by virtue of this filing affidavit, we have clarified that this is the fact. That inadvertently that wasn't put by the person concerned, and ultimately when it is detected, that he has clarified. That's all, my lord. Now the rest part, my lord, whatever he has in earlier occasion also, he has submitted that the running bill. Well, at the since as per this honorable court's order, it has been specified that till the next date returnable debt work order issued to the respondent number 5 shall not be acted upon any part. That was, and I have been restrained from doing the work by the authority concerned. That since court has passed the order, you need not do any work. Since then, I'm not working, and I have followed. I have complied with the honorable court, sir. So, since this honorable court is aware that since 70% work have been already completed, my lord, and now some other contractors, they are pressurizing the petition, this respondent number 5, to complete the work, so that whatever the furniture, all these things, whatever another contract part is there, man, they have to put the furniture, my lord. Now they are pressurizing the respondent number 5 to complete the building, and I have also pressurized. But
You
because of
succumb to
this,
the pressure, you do go ahead with the work.
no, my lord, since
What kind of submission is this?
my lord,
Some contractor is pressuring you.
no,
You,
that
succumb to
person-
the pressure, do
but-
the work on,
but, since-
violate the order of the court,
since-
face the
since-
consequence matter, and
since- no,
don't make this kind of submission, Mr.
but
Chetri.
since we
Some
are,
contractor is pressurizing you to
No,
put furniture.
no,
What is this?
I'm not on that, my lord. That part, my lord, since we have told before the authority concerned that since there is a court order, so we cannot do anything.
That we have understood.
Yes, that is why, my lord. The pressure is not meaning, my lord, since honorable court's order is there, my lord, and we have
Go
to follow
ahead.
it.
Succumb to the pressure.
Yes.
We'll
And
see what
since,
we
my
do.
lord, on this basis of the 70%, my lord, I have come across, my lord, some of the one of the honorable our High Court's decision, my lord. Here, my lord, basically,
Citation?
yes, my lord, 2022, 0 Supreme, Guwahati, within bracket Guwahati, 11521. The reference has been made, my lord, of the Honorable Supreme Court and all this.
Name of the parties.
My
Citation
lord,
of Supreme.
Naga Builders and Suppliers versus State of Nagaland, represented by the Chief Secretary.
Yes. Judgment dated?
Yes. Judgment dated 18/8/2022.
Yes, paragraphs?
Paragraph, my lord, Lordship will find paragraph
What is the ratio?
Yes, the issue, my lord, they have also this unsuccessful bidder also challenge the contract of the respondent number of the private respondents, my lord, on the same way. Here in para 15.5, my lord.
15.5.
Yes, 15.6. 17, 18, and 19, 21. Small para. May I supply, my lord?
Yes, please.
Here, up to date Supreme Court judgment has been relied on. The single bench order.
Paragraph 15.5.
Yes.
Fifteen point 6, 17, 18, 19, 20. Angie projects has been explained later. That is only pertaining to after the amendment of the specific relief act. It will not have a general application.
In 15.5, this is Chhattisgarh State Industrial Matter. And 15.6 is anti-limited.
Angie has been explained.
15.5 is Honorable Supreme Court had observed that as 15% last line. As 50% of the work was completed when the order in the repetition was passed by the High Court, no interference was warranted.
Okay. Yes.
And since Lordship is aware that when there is a specific pleading, he cannot go beyond the pleading. And my lord, here only he has hit it, my lord, on this particular point, the GSTN number, on this particular. And that is why, my lord, to that extent, we have already clarified. And probably, my lord, in this case, he doesn't have any case. My lord, Lordship may be pleased to dismiss the writ petition on the basis what we have submitted before, Lordship.
Now, paragraph 8, he has clearly pleaded that your supplier does not have a GST, and the GST number which was given, that is not that belongs to somebody else.
Yes, that part, my lord, we have already we have clarified by the My Enterprise as well as the respondent number 5. That has been clarified.
Okay.
And since it is up to your lordship to decide, my lord, since up to 40 lakhs, as per this notification, lordship has come to know. Up to 40 lakhs as supplier master must not have the GST. It's not obligatory, my lord. If his turnover is less than 40 lakhs. And this is small shop, my lord. Only supplying these materials and in the low rate. That's the only question.
Your
Well-
work is of how much? The estimate value is 33 lakhs.
30 estimate value is 33 lakhs. But here I have.
And Ma gives supply to all of you, 5 of you, all the materials.
5 of these wallet only he can supply the materials in the low rates.
Low rates, how many, what would be the price, what would be the
Well,
price of the materials?
There are two letters, my lord. One letter,
Mr. Chetri, if you are harping on these 40 lakhs, which should not be otherwise relevant because you have not made any, produced any materials that the turnover of Ma is less than 40. But assuming Ma is supplying to all the 5 contractors, the value of each of the works is 33 lakhs. And it is work contracts. Everything depends on the supply, cement, sand, rods, building materials.
only out of 5 cases, my lord. Out of
Leaving
5
aside
cases,
the labor component, everything will be supplied by Ma.
out of 5 cases, my lord, only these 4 cases, my lord, this construction has been made. And in one case, my lord, since there is a boundary dispute in WPC number 9981, here, my lord, regarding boundary dispute, that construction could not be made as on 998, WPC 99. The materials, my lord, in all cases, my lord, it's not that, my lord, there are, my lord, 2 types of letter, my lord. One letter has been submitted by my enterprise. Another letter has been submitted by the tenderer himself, where they have said that I have that much of stock in my possession, I can utilize in the low work. And apart from that, whatever is.
But how come the same stock has been shown by all of you for different work?
Because they are the registered contractor, my lord, they have the materials, my
The
lord.
same materials shown for all the different works. You are harping that these are different works, maybe under the same NIT, 8 works. You have, all of you have bidded for these separate works, but the materials which you have been shown is the same. There is not a difference in a single photograph.
No, these materials, my lord, since that has been shown and the authority has verified all these things. Had there been anything else, my lord, certainly authority had objected, my lord. There was no.
See, the authority depends on a verification exercise done by a junior engineer. Nothing to say about it. Very good. Junior engineer goes there, he brings photographic evidence, placed before the committee. All the photographs are the same. For different bids, same materials. Committee agrees.
No.
Where is the application of mind?
No, same materials, my lord, regarding sand, all this iron. All
Same photographs.
My lord, when lordship will take up the photograph of any materials, my lord, same photograph.
Same photograph. See the background. At least he should have changed the angle at least.
That part I do not know, my lord. Now, since.
You have it photographed from one angle, the other angle, then said these are different materials. We could have agreed. He had saved time. Okay, one photograph will do.
No. Since, my lord, that part, my lord, already, my learned friend has already clarified that they have gone through all these materials, my lord. They have found it. They have
Okay,
accordingly report has been submitted, my lord.
okay. Yes, any reply?
Lordship. The basic lordship difference of.
Mr. Nath, you wanted to say something? Add anything? No, after that, you
Yes.
will not get a chance. If you want to add anything in your thing, I think you had completed. In fact, you had completed.
I have.
Yes, anything, any clarification?
Yes, I'll place, I'll place that one on decision, I'll refer.
Okay, decision, yes,
Lordship
please.
kindly-
Yes,
Lordship
yes,
kindly take note of that.
yes.
I'll place reliance on the decision of the Bharat Cooking Coal Limited. Firm. That Lordship will see my respectful submission is to what extent the judicial review will, that kindly see, Lord.
Justice Bopana's judgment.
Bopan,
Oh.
Lord.
Bharat
No,
Cooking.
Bharat Cooking, kindly,
That is on the age, retirement, the superannuation age,
No.
overstay.
no, this is, Lord. This is relating to tender process, Lord. Judicial review in a contract.
Okay.
I'll, Lord,
Yes,
2020, 16 SCC 759.
2020, 16 SCC,
759.
75, judicial making process, the judicial review,
Yes, no, in contract matter.
decision making process.
Yes, yes.
Paragraph,
So paragraph will be, 29, 31 to 35,
29, 31 to 35.
35, and 38, 40. And the other decision is of AFCON.
Of yes.
These are the two decisions, I'll place reliance. In AFCON, his Lordship, 2016.
Yes.
16 SCC 818, para 14, 15, 16, and 7.
Okay.
And only one submission, as regard the report of the junior engineer, the junior engineer, he has verified the site, and whatever he has found, he has taken the photographs, he has placed it because that is the justification given by the contractor with the bid document, and he has placed it, and the evaluation committee has considered that, and they found that some materials along with the source, they have indicated that they have accepted with the additional.
Yes.
And there's no malafide or anything. Had there been any malafide intention, then angle, he may have changed the angle. Otherwise,
He had saved time.
no, there is
He
nothing.
was in a hurry.
No, in fact, whatever he has found, he has placed it before the authority, and the authority has rightly considered.
Okay, short
Plus,
reply.
Lordship, kindly take up request number 1078.
10?
1078.
What are we taking now? 1069,
1069.
1071,
1078, Lordship.
78.
In 1078, Lordship. The respondent number 5 has filed his affidavit opposition. And he has also annexed the Lordship work order. I am submitting, Lordship, in all work order was, Lordship, published in the website in different dates. Lordship will find that is what I'm saying.
Page,
Page, Lordship, it is mentioned as 63, annexure 6. It is the document of respondent number 5 itself, Lordship. Of Diganto Bora. So, Lordship, it was published on, Lordship, got it page 50.
just a minute, please. Yes,
Page
105.
63, Lordship, will find it below portion, Lordship. It was published on 25th of January 2024. His own documents, Lordship, the work order. Now,
25th of?
January 24. 117. 117. 117.
No, there are two dates, Mr. Kolita.
Lordship, 2 dates is there. One
First
is
is
the official
6.
date.
Yes.
One is the official date, Lordship, because we are not aware of the official date when they have, Lordship, they approve or recommend. We are concerned, Lordship, when it was published. So, Lordship, it is the document of respondent number 5 himself. So he has, it was published on 25th of January, 5th of January 24. Now, Lordship, the junior engineer has, Lordship, given a justification progress report that, Lordship, will find in the affidavit of respondent number 124 at page number 83. All have been Lordship in the same date. In the progress report is also on the same date, Lordship, all cases.
80?
83.
Yes.
Lordship. Work order was published on 25th of January and justification progress report was Lordship issued on 20th of February 24, showing it is 70% completed. So Lordship, despite Lordship, it is a very peculiar nature of case, Lordship. This petitioner has Lordship point out the person who is trying to cheat the government itself. And this official respondent Lordship supporting that the person who are trying to cheat. This is very peculiar, Lordship. Lordship, because the My Enterprise, he is supplying the goods in 5 cases. It will around Lordship, work value will be Lordship 1,50,000, 50 lakhs. Now 1,50 lakhs materials have been supplied without any GST number. First thing, Lordship. Second thing is that the contention raised by the respondent is that no GST number is required for the supplier. Here, Lordship is very much aware. I will rely upon the judgment of this honorable court chair, reporting Lordship Bhavananda Mohanta's case. Every clause of NIT Lordship has to be read independently, unless it otherwise Lordship explained in the NIT. So here they are relying on the clause of. They are relying on clause Lordship qualification criteria, clause 2, D, Roman 2 and 3. The GST number they have their GST number to the tender, not the Lordship supplier. The clause D is the final clause of this case, Lordship. So that has to be read independently. That cannot be Lordship amalgamated with other clauses. So this is the very Lordship vital case of this petitioner. So the person who is supplying more than Lordship 1.5 crores goods, he do not have any GST number, and meaning thereby Lordship he is sitting the government to Lordship but to evade the GST. First thing. Second thing, Lordship, all the progress report submitted by the junior engineer in the same date, same Lordship. All are in the same date. Whether Lordship he visited all the places at the same time. Number 3 is that Lordship, the clarification given by My Enterprise without having any seal and sign, Lordship. I am also Lordship suspect the document that they are relying. The clarification given by My Enterprise doesn't bear Lordship any seal of the My Enterprise also. GST is far away, not even the seal of My Enterprise. Lordship will find at page 77 in all cases, Lordship. This is a type paper only. Also, I Lordship, that is why I am suspect this and there is objection of these documents also, whether it was genuinely Lordship issued by My Enterprise. That is also an objecting Lordship. Because this is a type copy, not again the Lordship cash memo or Lordship paid of My Enterprise without any seal. And all these GST, all these papers, Lordship will notice in all 5 cases. Clarification given by My Enterprise is only the changes the name. Everything is same, Lordship. Same date, same contents, and this is a type copy. Whether Lordship My Enterprise given this clarification type in a Lordship type copy or in pen. So that is also Lordship very suspicious. So I am relying upon the judgment of the Honorable Court Lordship. This was reported in 2022 6 GLT.
2022?
6 GLT. Page number Lordship 698. Bhabadev Mohanta versus State of others.
Versus state of Assam. Yes,
Lordship, I am just reading one paragraph to clarify my submission, Lordship.
yes.
Paragraph number 12, only one copy, Lordship, I am just reading. Paragraph number 12, in support of his submission, the NIA, the learned senior counsel for the petitioner placed reliance upon the cases of Central Coalfields Limited and others versus SLML Joint Venture Consortium and others reported in 2016 8 SCC 622. In the aforesaid case, the Honorable Court has laid down that norms having been set, there cannot be any deviation. Reliance has also been placed upon the landmark case of Mohinder Singh Gill Successive Election Commissioner. reported
Those
in-
are submission, those are
Lordship,
known
yes.
to us.
No,
not required.
and
Come
findings,
to the
yes,
findings.
findings, Lordship, at paragraph number 34.
Hmm.
And 34, 36, and 40. Wherein this honorable court has held the all independent clause has to be read independently, Lordship. So here in this case, Lordship, the vital clause is the clause G. The person has to be, Lordship, justified his quotation regarding the low bidding price. And they have, Lordship, only formally submitted a justification, quotation and justification without any, Lordship, valid reason. Number one. Number two is that the planet famous, Lordship, raised the question of the person who has been placed at L2 and 3 bidder, they were not made party. To this regard, Lordship, I have already made submission in my additional affidavit in reply that those persons who are in L2 and 3, they also, Lordship, did not produce any, Lordship, justification report. They only quoted the rate beyond 15% without any supporting document. That is why I am not making them party. And if I am, Lordship, assuming that they should have been made party, then Lordship may direct the state respondent to, Lordship, reassess and give the person who is the lowest bidder. I will not object.
The L2, L3's bids were beyond 15%.
Beyond 15%, but without any justification report. So, Lordship, and other cases, Lordship, has already seen this petitioner is in L2 bidder. Other, Lordship, other two cases, this petitioner in package number 6, petitioner is at 2.
Yes, that those we have seen.
Yes, into C. So, Lordship, since the other two cases, the person who are in L1, L2, and 3, they didn't produce, Lordship, any justification report. Their case already automatically go. So, if the respondent, Lordship, on the basis of their document submitted, to reassess the, Lordship, bidding document, then this petitioner will entitled for all these bids. This all. The other, Lordship, that main issue is, Lordship, regarding the person they are trying to seek the government of the person regarding GS.
Okay.
And reports are also same, Lordship. So, Lordship, my humble submission. And one thing, Lordship, I'll say, Lordship, since they have violated the court order, either Lordship may take so much of cognizance, Lordship, or Lordship may allow me to, Lordship, liberty may be given to
No, it's
file.
not your case that after the interim order, they have progressed.
No, Lordship, after the, since the court has said not to proceed further regarding this work order, how can they release the amount, Lordship? They have, had there been, Lordship, any application to vacate the stay order, that was different issue. They have not filed any affidavit to petition to vacate the order. How can they, Lordship? They have to justify that. This is, if Lordship is not taking up, then I may be given liberty, Lordship, I will take Lordship to in contempt process. So, Lordship, that's my
Yes.
humble submission, Lordship.
In all the 4 cases, what are the same progress?
Yeah, 78, one by one, Lordship.
Except 998.
Yes.
That has not progressed.
Others say 17, 80.
No, 998, there is no progress.
There is some boundary dispute they have mentioned, Lordship. Others are 17.
998 is before us or not?
Yes.
There is no payment also in 998.
Payment also not yet.
No payment.
There's no work is done, Lordship, no payment yet.
Boundary dispute. Boundary dispute going on, madam.
Because once the interim order is passed, Lordship, without any, Lordship, modification, alteration, that cannot be, Lordship, filed by respondent. And respondent, Lordship, that's the judgment that I am relying upon, Lordship. Specific mention is there, although, Lordship, the respondent is the best person to read the documents, but they cannot deviate from the clause mentioned in the document.
Okay. Oh, इसको रिजर्व कर दो जे कोलिटा दीनाथ हाँ then Mr. Chetri, you are for R5 in all the cases. R5 in all the cases. You are for R5 in all the cases. Okay. Huh? B Chetri. Cases.
Well, at the cost of repetition.
And Dinath, Sri Dinath, Sri Sinaga and Bukit also produced the records in original. Hearing is concluded, judgment is reserved. Okay.
Well, at the cost of repetition, just
Don't repeat. Don't take the pain of repeating.
No, page 40, my learned friend has again indicated the work order. I have clarified, but he has indicated that the date at the bottom is the accurate date. Kindly below page 40 of this petition. He is now submitting 1178 of 2024. Kindly have a look at page 40.
1178.
1178, page
Yes.
40.
Yes.
Well, in the other case, the same order
Hmm.
of 6/1/2024 is the work order.
Hmm.
There the uploaded date at the bottom, he said that it was 13/2/2024.
Hmm.
Now in this case, page 44, at the bottom is 25/1/2024.
Yes.
So in fact, this is not the uploaded date. But this has been downloaded by someone and that date is shown. The date of the order is 6/1/2024. It is an well, e-office.
Now, what
document.
Mr. Kolita is trying to say that this is not his document which he has annexed.
Yes, Lordship. That is
It is the document of the petition.
Yes.
No, this is the petition.
No.
Page 40 is a document annexed by him in the writ petition.
Yes, and the reply also, I'm relying on reply to.
No, page 40 in the writ petition is a document annexed by him.
Page 63.
No, why not? Page 40, I'm indicating page 40. I'm indicating page 40.
And I am 63, Lordship.
This is his document.
And 63 is it?
Come to 105, annexure 6.
Yes, Lordship, annexure 6.
Mr. Chetri's document.
Yes, Lordship.
We did not look at the other page. We looked at 105, page annexure 6.
Annexure C. Yes,
Yes.
Lord.
25/1/2024.
No, this is the same page as of.
No,
page-
it is his document,
his
Mr. Chetri's
document.
document.
Lordship, so this 25/1/2024 at bottom, but the date of order is 6/1.
No, that we have seen. That we have seen.
So the,
Now, what Mr. Kolita is saying that it is not only the document which he is annexing,
Yes.
even the work order
Yes,
which the respondent 5 understands to be his work order has a date of 25/1/2024.
Yes.
possibly from the read petition, he has taken.
No, we do not know possibly what has happened.
Maybe, but in the record, kindly see,
We'll go by the records.
in the record, Malad, on 4/1.
6/1.
4/1/2024, it was approved. On 6/1, it was.
All these documents were taken from the restriction itself. Because
You don't have the work
They don't have
order.
Documents, yes. How
You
he-
don't have the copy of the work order.
It's completed without documents.
Now, you don't have the copy of the work order, it means.
yes, I have.
Then why you saying that you have taken his
Yes.
document?
Page 81, page 81, kindly see, Malad, page.
No, no, what Mr. Chetri is taking the document of the petitioner. Work order in favor of you.
Work order is 6.
Why will you take from the petitioner?
6/1/2024 itself, my lord.
No, we have annexed the work order at page
We'll go
80.
by the records, don't worry about those
Page
things, no
80.
respect.
Annexure 8, kindly take note of that. Our work order at page, annexure 8, page 81, in the affidavit.
Okay. Eh,
Lord.
okay.
Obliged, Lordship.
Yes,
Notify reserve. Lot. And the.
records we are retaining,
Look.
okay?
Lot, in the order, lot will indicate that type of
We have already said.
lot. I'm obliged.
Wait, no? Dina has put it, yes.
May I please, Lord?
Yes,
But in this matter, I am appearing for respondent number 3, my lord. On instructions, I am appearing, my lord. My senior is the sending counsel of the SID corporation. His name is not reflected, for which we could not appear in the last date, my lord. I pray for some time to file our reply in this matter.
agriculture has filed.
Lordship, we are not filing.
You file it, you have taken time on the last occasion to file.
2 weeks may be granted, Lordship.
How much time will you be requiring?
2 weeks.
Okay. What is your name?
Mr. A. N. Sharma, my lord.
A?
A. N. Sharma. my lord.
Okay. Heard Sri B. Das Learned Counsel for the petitioner, para. On a request made by Miss G. Bora, Learned Counsel for the Learned Standing Counsel Agriculture Department, and Sri A. N. Sharma,
Yeah.
Learned Counsel appearing on instruction of Sri S. Chamaria, Standing Counsel, Assam Seeds Corporation. 3 weeks' time is granted to file affidavit in opposition.
Perhaps
What is
lordship,
what is the subject matter?
non-payment of contextual dues, my lord. Let me just.
Okay, file it within 3 weeks.
My lord, Mr. Samaria's name may be.
A name of Sri S. Chamaria be reflected in the cause list.
I'm obliged. Please.
Okay, we'll hear the main writ petition. Mr. Well, yes,
My lords, to reiterate the context, I am a registered MSME, my lord.
yes,
I have been I was incorporated in the year 2019, my lords. The partnership deed is on record.
okay.
By
Yes.
virtue of the registration, my lords, I am covered under the MSME Act and the connected benefits that are extended to me by virtue of that act, my.
Yes, yes.
My lords, to be very specific, it's section 11 of the MSME Act.
MSME account লাগিব.
Wherein, my lords, I'll read for your lordship convenience. For facilitating promotion and development of micro and small enterprises, the central government or the state government may, by order, notify from time to time preference policy in respect of procurement of goods and services produced and provided by micro and small enterprises by its ministries or departments, as the case may be, or its aided institutions and public sector enterprises. Now, accordingly, my lords, the State Public Procurement Act of 2017, read with its rules, were amended, my lord. And
State,
the Assam Public Procurement Act of 2017. And thereafter, my lords, there were certain policies which were formed, which was the preference policies. The Assam,
when was the amendment done?
my lords, there was a preference policy which was notified in the year 2015, then 2020, then 2020, then 2021. We are covered under the 2021, my lords, which is annexed at A5, my lord. Page number 45.
Page 40?
Page 45, my lords, is the annexure A5. Relevant page number will be 47 for your lord.
Yes.
My lords, it reads in supersession of the procurement preference policy of Assam of 2015 and 2017, I stand corrected, my lord. The governor of Assam is hereby pleased to enunciate the procurement preference policy of 2021. Now, my lords may see the intent of this preference policy, my lords, which is important for this the instant case. Whereas in 2006, a central act, namely Micro, Small and Medium Enterprises Development Act of 2006, came into force. Section 11 of the Advocates Act of the Act advocates for promotion and development of micro and small enterprises. The procurement preference policy of Assam 2015, as amended in 2017, was formulated as per the provisions of the Section 11 to further the object of the Act. My lords, now may come to Section 4 sub 3, my lord, of the preference policy. My lords, the aids of interpretation is given on the left hand side of the column, my lords, to the provision, and it reads eligibility for getting preference under the policy.
Just a minute, please.
My lord.
Yes.
At page number 49, my lords, section 4 sub 3, my lord. The aid of interpretation is on the left hand side, my lords. It reads eligibility for getting preference under the policy. At subclause 3, my lords, it says any micro and small enterprise who has obtained an Udyam registration shall be eligible under the policy.
Subclause 4.
My lord,
Subclause
section 4, subclause 3.
3. Okay. 4(3). Udyam registration.
Yes, ma'am. Now, my lords, there's one more point which is important to be highlighted, my lords. In the same section, my lords, there's a subclause 9 at page 50, my lords, right on the top.
Yes.
It says the policy will not be applicable for procurement under external aided projects. My lords may note this submission of mine, my lords, and I'll come to that in a bit. My lords, the next highlight will be section 7 of the same policy, my lords, which says mandatory procurement from small and micro enterprise.
Yes.
And my lords, 1 and 2 is relevant in the incident case, my lords, and the effect is that even if I am found unsuccessful as the L1 bidder, my lords, there is a compulsory supply of 25% which has to be given to a micro and small enterprise, which is lesser than the L1 bidder. My lords, and that submission of mine is found in section 9, my lords, which says purchase preference on page 51, my lord.
Yes.
It says, my lord, subject to the provision of this policy and to any specific instruction issued by the nodal department or in pursuance of this, purchase preference shall be given to a local micro and small enterprise. Subclause 2 states, my lords, that the micro and small enterprise or startup who will quote the price closest to the L1, who is not a micro small enterprise or startup, will be given the price preference and supply order of 25% of the total quantity tendered.
Yes.
My lords, then we are on section 13 of the same policy, my lord, which provides action for non-compliance of provisions of this policy for purposes of implementation.
Yes.
It reads, my lords, in case of restrictive or discriminatory conditions, and this is what my principal submission is, my lords, and therefore the highlight. Against domestic suppliers are included in the bid document. An inquiry shall be conducted by the administrative department undertaking the procurement, including procurement by any entity under its administrative control to fix responsibility for the same. Thereafter, appropriate action, administrative or otherwise, shall be taken against the erring official or procurement entities under the relevant provisions. Intimation on all such actions shall be sent to the review committee. The only exception which has been carved out under the policy is found under section 15, my lords, of the same page.
Yes.
Which reads, my lords, that every procurement entity shall first prepare a procurement plan along with its annual budget. Allocations for a financial year and a plan shall be updated as per approved annual budget allocation of the entity. This updated procurement plan shall be approved by the concerned administrative department within 15 days of the receipt of the budget communication from the finance department, my lord. And then lastly, on the same policy, my lords, I'm relying upon 17, which gives that exemption, my lords. There has to be a my lords, 17, my lord?
Yes, yes.
The administrative department undertaking the procurement by any entity under its administrative control with the approval of their minister in charge by way of a written order. My lords, this is the exception that they can, if a certain tender is found that, okay, I want exceptions for this particular tender, I can apply for that. Now, my lords, may I have page number 395, my lords.
$395. Not 395.
395 of the rejoinder, my lords.
Okay.
It's annexure A11. My lords, this is a office memorandum which has been issued by the government of India, my lords, which says what can be the examples of restrictive and discriminatory conditions against local suppliers. My lords may have page 396, which is the annexure A, which depicts that, my lords, this is now paragraph E, which says excessive past experience requirement not commensurate with the proven experience expected from the bidder or successful execution of the contract. My lords, this directly covers.
What is it? Please read again. We have not understood.
My lords, these are the
examples, illustrations.
Example.
Now, what is E? What is you are relying upon? E.
My lords, I'm saying that the tender conditions which has been set for the, as far as the technical criteria goes, is highly restrictive and not participative at all, my lord. And therefore the reliance on this annexure matter. A11,
Excessive power experience is a restriction. They should not impose.
yes, my lord. The whole point of the MSME Act is in wider inclusion. Then, my lord, is a clarification which has been issued by the MSME department at page number 390, my lord.
390.
390. This is issued by, again, by the Government of India, Ministry of Heavy Industries and Public Enterprise, my lord. It runs into a couple of pages.
Yes.
My lord, the relevant page will be 393. And 394, my lord, which, my lords, what has happened is ever since the 2006 policy came out to be, there was a confusion which was created between the terminology which was MSME and startups. All startups may be MSME, my lord, but all MSMEs may not be startups. However, there is a clarification which has been issued, and this is recorded in 394, my lord, that the same benefits will be extended to an MSME as well. And inter alia, which includes the relaxation of norms and the bid price and the fees for the tender and so on and so forth.
Where is that part?
My lord.
Same would also be.
My lord, may I have 394, my lord?
Yes.
394, I'll read, my lord. Relaxation for norms for startups and micro and small enterprises in public procurement or prior experience, prior turnover criteria. The Government of India has announced a Startup India initiative for creating a conducive environment for startups in India. The startups are normally micro and small enterprises which may not have a track record. They will have technical capabilities to deliver the goods and services as per the prescribed technical and quality specification and may not be able to meet the qualification criteria related to prior experience.
We'll continue at 2 o'clock. Mr. Usman.
My lord. Of the public procurement policy for MSME order of 2012, my lords, is forms parts of the MSME Act, my lord. This is page number 19 of the BEAR Act. The point was, my lords, that there was a clarification which was issued that all startups are MSMEs, but MSMEs may not be startups. However, under the MSME Act, because certain relaxations have to be granted, my lords, all MSMEs, the benefit should be extended to them ordinarily, my lords. That's what an overview of this order says. Now, my lords, I'll come to the tender, which is page number 75, my lords, of the main writ petition. These are the technical tender qualification, my lords, which my lords may find it at page number 75. Serial number 2, my lords, reads, the bidder should be a registered company or a firm and should have been in existence for at least 10 years on opening of the bid, my lords. It hits directly every provision which grants me that benefit or that facilitation and is contrary to public policy, madam. Both of the center and the state, madam.
Which 75, which
75, my lords, we see para number 3, bidder eligibility criteria.
Yes.
Serial number 2, my lord.
Yes.
Now, thereafter, my lords, what happens is I approach this honorable court with my grievance, my lords, and there is a specific submission which was made by me, my lords, which was recorded by way of the order dated 10/4/2024, my lords.
10/4/2024.
10/4/2024 of this honorable court, my lord. At that point in time, my lords, the submission was that because this tender is of a value which is over and above 20 lakhs, my lords, as per the state directions, the tender has to necessarily go through the e-tendering mode on the Assam tenders portal. My lord.
Yes.
My grievance was, my lords, that I can't participate because of the fact that I have to now select. The tender conditions will not allow me to go forward because I have to select a couple of criteria in the
Now
tender.
you said that you are allowed to go
Yes, my lord.
physically.
I'm showing something
Yes,
to your
yes,
lordship.
Yes.
What happens is, my lords, there's a direction of this honorable court at para number 5, my lord.
Yes.
It reads, as submitted, the tender is scheduled to be opened at 3 p.m. today. Hence, the court is inclined to provide that if the statements made by the learned counsel for the petitioner is correct, which basically means that I am precluded from applying, that while applying via the online portal, the exemption could not be claimed. And for being incorporated before 10 years, the portal did not accept the tender. The respondent authority, specifically the Assam Skill Development Mission, the respondent number 2,
Yes.
shall accept my lords, by virtue of them accepting my physical bid, it's an admission on their behalf now. The same averment, my lords may find at 202, my lords, in para number 9. Thereafter, my lord,
20.
page number 202, my lords, para number 9.
What is it?
My lords may have.
Yes.
Para number 9 reads, my lords, that it is most humbly submitted that the respondent number 2, having accepted the submission of the physical bid by the petitioner.
No, that is okay. You
My
have
lord,
said
my
it.
lord. Thereafter, my lords, there's a reply which comes on records, my lord. This is on internal page number 238. Para number 4, my lord. And this is connected to this submission, my lord.
238.
Now, my lords, their defense stands on
238 paragraph.
238 paragraph number 4, my lord, which reads that with regard to the averments, the deponent states that the Assam Procurement Preference Policy 2021 does not mandate the implementation of its provision in every government tender. This is their position, my lord. Number one, and the other challenge which they have mounted, my lords, is of maintainability, saying that I am precluded to come before your lordships by operation of 38, my lord, and I'll come to that, my lord. This section 38 of the Assam Public Procurement Act of 2017, my lord, which starts with the words subject to section 40.
You are reading?
The Assam Public
Page?
Procurement Act of 2017, my lord.
Is it there? Part of the record?
My lord, probably not on the. Is it part of the record? It's not part of your record.
You
I
have an
have a
extra-
spare copy.
पीछे नहीं क्या पता relevant पेज कटा हुआ है
This is the act together with its rules, my lord. Now, the Assam Procurement Act of 2017, my lords, the second defense that they mounted is that I am precluded to come before your lordships by virtue of operational of section 38 of the act, my lord. If my lords may have section 38 subclause 1, my lords, it says it starts with the words subject to section 40. And my lords, I'll go to section 40 first, my lord. My lords have section 40.
Just a minute. $38 is the appellate provision, isn't it?
38 is the appellate provision. 40 is a.
Yes.
40 says, my lords, appeal not to lie in certain cases, my lord.
Yes.
Subclause B says provisions limiting participation of bidders in the bid process in terms of provisions of section 6, my lord. 6 enables the MSME provisions and the act, my lord.
No appeal shall lie. Yes.
Thereafter, my lords, may have the first page of the tender, which my lords may find it at annexure A7, my lords, of my at page number 63, my lords.
Yes.
That's the tender, my lords. My lords may turn to page number 66, which is the overview prepared by them, my lords, the respondent number 2.
66.
Page number 66, my lords.
Yes.
The crux of my submission is this, my lords. The Assam State Development Mission, by virtue of their own document, my lords, is funded by 3 streams of finance.
Yes.
The first is the state, second is the center, and the third is externally aided projects which they have to declare, my lord. Now, at the time of preparing these tenders, my lords, they have to make these disclosures as to specifically what, which stream are they from the finances of which stream are they implementing this particular tender, my lord. Now, at my lords may have page number 84, my lord. '84 states, my lords, at paragraph 16, general terms and conditions. Applicable law means the law and any other instrument having force of law in India for the time being in force. And subclause 6, my lords, say government means government of India and Assam.
Yes.
Then my lords may have page number 88, my lord, which further gives that clarification. At 22, my lords, the governing law. The agreement shall be governed by and interpreted in accordance with the laws of Assam, the country India, my lords. Now, what they're trying to say is that and this is my interpretation now, my lord, that given the nature of the tender, there may be and they have not come on record and clarified this position at all, my lord, that there may be a possibility where they're implementing finance of the center and the state together in this particular tender because of the culmination of very many activities which have come together. Now, my lord, I am a past allottee of my submissions remains true, my lord, that I am a past allottee performing near similar works, my lord.
Yes.
In fact, I was also given the principal tender, the old tender, my lords, was given to me for 1 year, my lord, for a duration of 1 year. Thereby, it was extended for a period of 3 months, and an extension was ultimately given to me till 30th/11/2023, my lord.
You are the previous lessee.
Yes, ma'am. I have, my lords, for your convenience, my lords. Now, both the tenders are on record, my lord. I have prepared a convenience document, my lords, which gives a comparison of what the old tender is and what the new tender says in my comment.
Okay.
Yes. There's a considerable overlap, my lords. There's only a difference of terminology. Ultimately, my lords, I am well within my qualification and sufficient experience to implement this whole tender, my lord.
Yes.
After that, my lords, by virtue of the previous order, my lords, which is 30th/5/2024, my lord, what happens is this honorable court gives them the discretion to go ahead and evaluate the tender, open the technical bid and the financial bid.
Yes.
In the technical bid, my lords, I am disqualified by saying that I do not meet the 10-year criteria, number 1.
Okay.
Number 2, my lords, it says that I have not annexed certain documents.
Yes.
As far as the technical criteria goes, which says that I should have put in work completion certificates of a value of more than 1 crore, my lords. And my submission is that I had, my lords. What had happened in the intervening period was that there was incessant rains in Guwahati, my lords, and I could not reach the venue in time. Before I could reach, by a delay of a couple of hours, my lords, they proceeded to open the tender and they did not even allow me in the premises, my lord. Now, this is captured by way of an email. That email is also on record saying that please give us the data. the second leg of the arguments is, my lords, that they have also now come on record to say that they have proceeded to open the financial bid also. After a considerable delay, ordinarily they should have opened the financial bid then and there. Now the financial bid is opened on 29/7/2024.
29?
7/2024, my lord.
Yeah, financial bids opened.
Financial bid open, my lords. And the data was to be shared with me, my lord. And this has a very big impact on my standing as one of the prospective bidders. My lords may note that there are only 3 bidders, my lord.
Okay.
Now, if I am disqualified, the responsiveness is only on 2. And I'll come to that aspect as per the procurement policy later. Now, my lords, there are 2 legs to these arguments on the aspect of the financial bid. If the financial data is not, I mean, I was not allowed to participate online, my lords, for reasons which I've just narrated. For the purpose of transparency, I requested them very humbly that the technical bid should be, all the bids should be opened in front of me, at least my bid, where they have said that, no, this will be kept in a sealed condition and I will take a decision on it at a later date. Agreed, my lord. My only contention was open it in front of me, my lord, so that at least there is some transparency to it. In any case, my lord, there is, and the compilation is before your lordships, my lords. This is rule number 23 of the Assam Procurement Act 2017 rules, my lord. This is rule number 23, sub-rule 14. The title reads clarification of bid. My lords have it?
Yes.
To assist in the examination, evaluation, comparison, and qualification of the bids, the bid evaluation committee may, at its discretion, ask any bidder in writing for clarification regarding its bid specifically by a specific date, my lord. No such clarification was issued to me, and my lords, my earlier submission was also this, that as per industry standards, my lords, ordinarily, if the index reads that I have put in certain documents and the documents are not complete in all respects, my lords, so clarification can be ordinarily issued to me. These are curable defects. And my lords, now again,
No, this in what context are you referring?
Their allegation against me, on basis of which they have disqualified me, saying that I have not put in the work completion certificate.
But that you did not reach on in time.
No, my
Where is
lords,
the scope of
I
clarification?
did not reach on time. They opened it, and my lords, what I'm trying to say, I was trying to be a little sensitive, my lords. I'm saying that they have been arbitrary, their acts have been arbitrary and they have been biased against.
No, this clarification will come when there is a confusion of document.
Yes, my lord.
When the documents was not given to them, you may have good reasons that we are not even exploring whether we accept or not.
My lord.
But it's not a matter of clarification. It's a matter of not using.
What my submission is, my lords, is that when I prepare the master index, all other documents are there, my lords. My work completion certificates are also mentioned as part of that index. And those are not just one work completion certificate, my lords. There are 7 to 8 of them. And also issued by the government of Assam, my lords. Different departments, different user departments, my lords. So it's not something which I have control over. The third aspect is in the qualification, in the technical qualification is they have made a noting saying that I have only paid 50% of the EMD. Now, my lords, my contention is that if the relaxations as per the Act, the read with the 2012 order and the preference policy is read together, my lords, I am entitled to that benefit. Thereafter, my lords, when the 27/9, they have now come on record to say that, well, I have opened up the financial bids, my lords, I'm completely in the dark. I do not have those documents on record. My last submission is this, my lord, that even if the financial bids are open,
yes,
and the law is applied in its spirit, my lord, I am still entitled to 25%.
Yes. Yes, Mr. Goswami.
May it please.
Yes.
On the submission of my learned friend, as per my understanding, my lord, then if he does not have any qualification with regard to the requirement of the
Have a
authorities,
seat, Mr. Khanna, have a seat.
my lord, authority is bound to give him some amount of work. What you will kindly see, my lord. First, writ petition, page 65.
Yes.
This is the tender, NIT, 5/3/2024.
Yes.
And the last date of submission, my lord, serial number 1. Last date of submission of tender document is 26/3/2024 up to 5 p.m. First, the bid will be open on 27/3/2024 in the office of the mission director, so and so. The date and time of the present bidder will be declared, so and so, so and so. The technical qualified bidders will be notified after financial bid opening through website, so and so, so and so. Submission of bid sale through the online mode only. Further details of the corrigendum subsequent communication may be seen at, this is the, my lord. 7, pre-bid queries. Pre-bid queries, if any, may be mailed to mission director, Assam, so and so, so and so. No whole bid queries will be accepted after that. My lord, the first, as per the first, my lord, the notice, my lord, no one came forward. No one, my lord, came forward. Then
No one came
second,
forward, there was no
no
bidders.
bidder. Second time, no bidder.
This was the first notice.
This is the first, my lord. Then corrigendum was issued, my lord. Second time, my lord, was on 27/3/2024. No bidder.
27/3/2024.
3/2024.
This was the second notice.
Yes, second corrigendum.
First corrigendum.
Sorry, first corrigendum. Then second corrigendum, my lord.
Yes.
10/4/2024, my.
10,
10/4.
Yes.
Second
corrigendum.
Yes. Meaning thereby, only after third time,
Yes.
the authority was able to proceed with, my lord, as per the NIT. My lord, in respect of all contracts, not
Now,
to speak of,
in the second corrigendum, 3 bidders participated.
yes, my lord.
Including the
yes,
petitioner.
including him.
Yes.
That part of that aspect of the matter, the petitioner has not disclosed. And petitioner also has not disclosed that this NIT clause 7, my lord, pre-bid queries, he has gone to the extent of appeal, my lord. No one has questioned the, my lord, the issue of appeal, my lord. The lordship will see pre-bid in respect of all government contracts. As per the suggestion of the contractors, authority is always, if necessary, my lord, changes are made. That is why this clause is always given, my lord. And the petitioner did not have any time, my lord, to go through this, and nothing has been submitted, my lord, if any grievance was there. And my lord, one primary thing, my lord, the petitioner has not done the, my lord, the job of the service provider. He was earlier he was running a call center, my lord. Call center was no near, my lord, similar, not at all connected with the present, my lord, work, my lord. This is, my lord, skill development for the purpose of engagement of the Assamese youth, my lord, here within the state of Assam. Why 10 years he was given? He not even, my lord, completed one project in software, my lord. Not to speak of 10 years. That is why he did not submit his tender, my lord. And there was no bar to submit his tender online through online process. Lordship will see the order, how he got the order, my lord. Once again, here's the read, my lord, I am reading it. Order dated, my lord, 10/4/2024.
Yes,
Last paragraph,
yes.
paragraph 5. As submitted, the tender is scheduled to be opened as per the last, my lord, last extension, my lord, at 3 p.m. today. Hence, the court is inclined to provide that if the statements made by the learned counsel for the petition.
Mr. Goswami, just a minute. If this is order is of 10/4,
Yes.
the second corrigendum, I think will be
Sorry.
of, not of 10/4, I think it will be slightly earlier.
Oh, earlier, yes, yes. He has submitted his on.
No,
10.
that's the last date,
Yes,
that's the last date.
yes,
I think,
yes,
what is the date of the corrigendum?
Yes. Yes, ma'am. May I read it, my lord?
Now, what was the date of the second corrigendum?
First one is
27/3.
yes, first one is 27/3. Second one is 10/4, my lord.
10/4 was the last date.
Yes.
What
No,
was
no,
the
no. 10/4, 9/4 was last date as per the second corrigendum.
9/4?
When there was no bidder, my lord. Then, my lord, 10/4 issued. 10/4 corrigendum.
Cannot be.
My
10/4,
lord.
he, well, just a minute. We'll come to you. 10/4, he has the order of
Yes,
10/4.
even then, my lord, this is corrigendum of 10/4. my lord. The authority issued 10/4, corrigendum on 10/4.
Where is it?
My lord, it is on the record.
10/4, I do not think. Yes, Mr. Khanna?
I-
My lords, the
Just-
corrigendum is on annexure B4, page number 219, my lord.
Yes.
What happens is, after they're in receipt of this order of this honorable court, my lords, they extend
Okay.
on 10/4, and the last date is given 25/4, my lord.
Oh, you're correct. correct.
But,
Okay.
my lord,
No, I am also saying 24, last date was, it was open on 26/4, last date, that is 25/4. That is nothing to
Okay.
repeat this.
No.
Only what I am submitting is, my lord, lordship will kindly see at page, paragraph 5 of the order of this honor. Once. In fact, petitioner, my lord, with a view to obtain an order and to frustrate the, my lord, the larger interest of the state, my lord, the present case has been filed. Lordship, my lord, may I read it, my
Yes.
order I mean. As submitted, the tender is scheduled to be opened at 3 p.m. today. Hence, the court is inclined to provide that if the statement made by the learned counsel for the petitioner is correct, that while applying via online portal, the exemption could not be claimed, and for being incorporated before 10 years, portal did not accept the tender. The respondent authority specifically so and so shall accept physical bid of the petitioner if the same is filed within 3 p.m. today, along with the downloaded copy of the order, if certified. My lord, there was no bar as such to submit the tender through online process. Only thing, my lord, to avoid the payment of, my lord, earnest money deposit 5,70,000. Without giving that money, my lord, no one can submit his tender through online process. My lord. Since, my lord, he was not inclined to give that amount of money, my lord, that is why he came to this court, my lord, and without disclosing the material fact and saying that this is a bar because 10 years experience is there. He did not have the 10 years experience, so authority will bar him. No bar as such. Only bar if he fails to
make the payment of rupees 5,70,000, my lord, then only,
What is that 5,70,000?
my lord, that is earnest money, my lord. He deposited 2 lakh, তুমি এটা বাহানা, please, পিছত কৰিবা না। তোমাৰ কিবা আছে মই
It's 5,40,000, not 70.
Yes, 5,40,000, yeah, all right. He 2,70,000, he deposited. So this is also, my lord, not correct state of affairs. Even to obtain the order of this honorable court, my lord, correct state of affairs was not revealed, not disclosed, my lord. And my lord, to get the benefit of the act he has referred to, my lord, among the equals, he is eligible to get there. He is not the among the equals, my lord. He is not at all eligible, my lord. Call center is no way connected with the present tender, my lord, the work of the present tender, my lord.
But he says that under the act.
My lord.
which
Yes,
government-
among the equals.
No,
We are,
you are
we
not,
are saying in the act, we are referring the act, no one can get a job, my lord. Because to get that, he has to experience. He is a, my lord, we are only, my lord, about the software business, my lord, not the hardware. He is in hardware business. And he is seeking, my lord, software work, my lord.
no, we are not on that. The insistence on the experience clause
My
for
lord.
an MSME,
My lord.
which this council is trying to emphasize, that the act you are not supposed to insist on the experience clause.
Yes, my lord, that is also in respect of that is startup, my lord.
No, it applies to both. The further clarification has been given as per the notification
My lord.
that initially it was thought to be a different. So
My
for
lord.
startup is different and MSME is different.
My lord.
But later notification says that you have to treat them at par.
My lord.
So if he is either a startup or an MSME, it will not make any difference.
Even if that is accepted.
Yes.
That is accepted.
Yes.
He is a, my lord, bookseller.
Okay.
He can supply only book, my lord. He cannot supply other than book, my lord.
No, to term him as a bookseller, he has to show an experience that I am a bookseller.
No, he has failed to. He
No,
has
no,
been
suppose he doesn't have any
lord.
experience either in bookselling or any other thing.
My lord.
He wants to participate in a job of bookselling.
My lord.
Can you preclude him from?
In respect of business of book, my lord, he cannot be precluded. But other things he cannot supply. Because
No,
in the tender process,
Mr.
my lord,
Mr.
my lord.
When the act says that you cannot insist upon the experience clause,
My lord. My lord.
whatever business or whatever job you are trying to get done through a tender process, can you insist that an MSME or a startup has to have the experience in that particular field?
My lord, if someone does not have the experience and the involvement of the particular business, how you will do it, my lord?
No, we don't know. We are going by the statute.
Yes, my lord. But
Statute.
the tender, whether the NIT allows him to participate without all this, my lord, all this, my lord, necessary that the requirement.
Mr. Goswami, the entire projection on behalf of the petitioner is based on
Yes,
that he
act.
comes under the MSME Act.
Yes.
And he gets certain benefits.
Yes, yes. But
And
my
he-
respectful submission on that part, I will make submission, man. On that part, I
No,
will
that
say,
is the issue involved.
my lord.
that is
Only
the
thing,
issue.
my lord, my respectful submission is, my lord,
Yes.
that is not relevant to decide the present issue. Because in view of the fact that, my lord, lordship will kindly see eligibility of the
Yes.
tender. Nothing here, according to him, my lord, it was an arbitrary exercise of power. Discrimination was there. My lord, paragraph 75. Sorry, page 70,
70?
75.
Yes.
Bidder eligibility criteria.
Yes. Yes.
May I read it, my lord?
Please.
Clause 3.
Hmm.
The bidder must have office in Guwahati, notarized declaration to open an office in Guwahati after
You are
the
reading where? Serial 1.
serial one. My lord.
Okay.
First, I'm
Okay.
coming one after another.
Yes, yes.
The bidder must have office in Guwahati, notarized declaration to open an office in Guwahati after the contract is awarded.
Yes.
The bidder should be registered company firm and should have experience for at least 10 years as on opening the bid. The bidder should never have been blacklisted so and so and so. The bidder firm shall not under declaration of so and so and so. These are not
Others are
relevant.
not relevant.
Yes.
We are on serial number 2.
Yes, my lord. Then serial number 8, my lord. Bidder should have implemented at least one project in central, state, PSU, public listed companies, which project value of 1 crore or more in software development, implementation with maintenance in development. So this is the specific requirement, my lord, for the purpose of the work.
This requirement, will it be also applicable for an MSME?
My lord, certainly, my lord, it will have to be, my lord, there, my lord. Otherwise, the very purpose of, my lord, the service, this is a service provider, my lord. Very purpose of service will be frustrated, my lord. Will have no use, my lord, then. Only giving the contract to someone, my lord, how the state will be benefited. To give benefit to a particular person, not the basic concept of inviting tender is not to
No,
give
let,
benefit to a particular.
let us read again ultimately it will boil down to whether an entity under the MSME Act of 2006 and the state government's procurement rules which have been amended
My lord,
subsequent to
these
this
are
act.
all preferential, my lord. This is in respect of preferential people. If someone lacks the eligibility, how can preference be given to the person concerned? This is all preferential treatment. My lord. Preference certainly for the purpose of giving the preference to the local youths. All acts are dear, my lord. Provisions of the acts are dear, my lord.
Let us read the act. Let us ultimately we have to go to the act. What benefits, what exemption do the act and the rules provide?
My lord, in the read petition itself, I think, petition like it. Page 50. My lord, before that, may I complete this?
Yes, please.
So this is the, my lord, requirement. And the very purpose I have explained before your lordship, my lord. The very purpose of inviting and he was not the existing contractor in respect of this all near similar service. As he said, my lord, earlier he was engaged.
Yes.
In this. This is absolutely incorrect. He was running a call center that is in the year 2023. Even the similar nature of work that has also been upgraded, my lord, this time. September 2003 itself, 2023 itself, his work, my lord, so far call center work is concerned, it is complete, my lord. And call center work is no way connected with this, my lord. Which we have stated in paragraph 6 for our affidavit. And lordship, why 10 years is needed, my lord? My respectful submission is, my lord, present software is being developed by software tools of 10 years old and technology evolved from past 10 years. That is why experience is needed. And my lord, so far clause 838.
No, Mr. Goswami, we are not even questioning your domain or your what you require for your job to be done.
Right.
We are only concerned that whether as an MSME he is entitled to certain exemption and whether those exemption has been given to provided to him or not. That is the only concern of ours. What conditions you want to impose, unless those conditions turns out to be or can be demonstrated to be absolutely unreasonable or arbitrary or onerous, extremely or to favor somebody, we will not enter into those. It's your domain. But he is making out a different case.
My lord.
10 years he is not questioning.
My lord.
Or 1 crore also he is not questioning. He says that I am an MSME, I don't want to,
My
I
lord.
don't need to.
My lord, merely becoming a MSME, my lord, will not be able to get the job. Because this is a work relating to service in respect of software, my lord. Software service is a service provider. So in respect of this field, the eligibility of the petitioner is lacking. In that case, merely relying on the provision of the act in respect of preference, my lord, he cannot be allotted to a job.
But how do you overcome the exemption given to a startup? A startup company, he doesn't have an experience.
If it is a similar nature of work, my lord. If it is similar nature of work,
No, Mr. Goswami, once we use the expression startup,
my,
there cannot be any experience of similar nature or otherwise.
otherwise, my lord,
Startup is a new project, new venture. How can they have an experience?
my lord, they have already experienced in the
No,
in
no,
the
we
field of-
are on a hypothetical case. We are not on their experience of running a call center.
Right.
Suppose a startup.
Right.
What is the meaning of a startup? We
Right.
open up a venture to do something.
Right.
In those, and if we are registered under the particular act of 2006, we get some certain exemption. We find that an
Okay,
NIT.
but he was never engaged in the field of this subject matter, software development. This is entirely software development matter. How can he be allotted, madam, when he is not engaged at no point of time?
Let
for
us
this
see the
top-
provisions of the act again, where exemptions have been given.
Section 5, my lord. Yes. Starts from 47.
47.
Right.
Yes.
And special provision, my lord, relevant provision, my lord, that is 50.
Huh? 50.
My lord.
Eligibility for getting some production facilities. Mr. Khanna, you fulfill the requirements of 4
My
at
lord?
page 49.
Of
Procurement.
procurement policy, my lords, you're on the paragraph for eligibility of getting preference. My lord.
Yes, you get.
My lords, my lords may have subclause 3, my lord.
No,
4(3). I have a Udyog registration, my lords, which certifies that I'm an MSME for the purposes of the act.
And as per my understanding, my lord, he is entitled to the benefit of, my lord, issue of tender, say, free of cost. 50% exemption from payment of earnest money, 50% waiver in payment of security deposit.
These are exclusive, mutually exclusive, or any one of the clauses?
My lords, any one of the clauses.
You are under Udyam registration.
Yes, my lord. And the MSME department has clarified that position as well, my lords, as per the under the order of 2012. My lords, let my learned colleague finish the arguments, my lords, I'll rebut.
4, 3. Okay, he fulfills Udyam.
My lord.
Okay, sit down. He fulfills 4(3).
4(3)
at page 49.
4(3).
Udyam.
Any micro and smaller who has obtained a Udyam registration shall be eligible under the policy.
That means he is eligible.
My lord.
Number 1. Then, what do you want to show here?
Yes. Special provision for startup.
Yes.
These benefits are here, according to my understanding, my lord, these are the benefits which can be granted to the persons like that of petitioner.
Yes.
Startup registered in Assam shall be eligible to avail the following benefit: issue of tenders set free of cost, 50% exemption from payment of earnest money. B, 50% waiver in respect of security deposit,
Okay.
not in a respect of experience.
Now, where is the experience clause?
As per the NIT, my lord, I am referring.
No, no, in the
No, here-
procurement policy.
I think it is not here. Subject to correction. Sir.
My lords, may I address?
No, we will come to.
Let me see.
And they are relying upon the rejoinder at 396E, page 396E.
Excessive past expense requirement not commensurate with the proven experience. If therefore, like, up. Yes.
Excessive past
Excessive past experience requirement not commensurate with the proven experience expected from bidder for successful execution of contract.
Okay.
Hello, the one document he is relying on, madam. Hello, page 383, madam.
Yes.
What he has submitted.
Hmm.
Can you submit for us?
383.
These are the experience. His experience.
Yes.
Not at all related to software. And we are only in software.
Yes. What about 4? Supply installation name of the nature of the work done?
Yes.
3, 4.
Okay.
383.
Assam related installation of software application in the assembly house. This is installation of software application in the assembly house.
Yes.
This is not like that of the contract that has been proposed to be given. And my lord, the certificate that is required to be given, my lord, that has not been, as we have submitted, my lord, on only hardware, software, no project completion certificate he has submitted. That is also 4,98,000. We need 1 crore, man.
But your submission that it has none of the works which are mentioned in this chart relates to the present job.
Right.
That does not appear to be correct. There are many of the jobs, maybe the valuation is less.
Yes.
But it relates to software
Yes,
installation.
my lord, that authority was specific in respect of, my lord, the NIT, my lord, provision of the NIT, my lord. The
Hmm.
bidder should have implemented at least one project in central state government public in listed company with a project value of 1 crore or more in software development, implementation, and maintenance in development exclusively, my lord. Because it is a work more than 1 crore.
But if you come to the relief which the petitioner is seeking,
Right.
he goes to the route saying that in setting up a restrictive eligibility criteria
My lord,
of insisting on minimum of 10 years, that is arbitrary.
my lord.
So far as an
So
MSME
the
is
condition
concerned.
cannot be, my lord, said as per the wishes of the, my lord, wish of the person concerned.
No, had he been any other tenderer,
My lord,
bidder,
my lord.
we would not
Because
have
all
even,
the,
you
my
would
lord,
not have even explored the.
This, all the technocrats or the engineer in software engineer, all this is the decision of those people. Considering all aspects, not
No,
that, my
Mr.
lord,
Goswami, so we are not, you are not disputing what you are saying.
Right.
Normally, you will take the decision until it appears to be absolutely arbitrary.
Right.
But we are examining this issue in the context that he is an MSME.
Right.
Wherein you cannot put in excessive conditions even for experience.
my lord,
He says that 10 years of insisting is minimum 10 years is violative of that notification at 393.
my lord, this service provider centering Guwahati, if the selected bidder, my lord, will have to do his part, my lord, for throughout Assam, my lord. Not for a particular placement. District-wise center, subdivision-wise center. My lord, it's a big job, my lord. This is not a small one. That is why all these conditions are there, my
You have opened a financial bid, price bid.
financial, yes. But it is not made public because Honorable Court says.
Do you have the outcome in a seal cover or what? Mr. Khanna, you know about your bid offered value?
My lords, I have to seek instruction.
My
You
lord,
don't
that,
have.
Not on the
that
financial.
Part, that part, my lord, only one last.
Not on the
submission
financial bid, my lords, I don't have
Financial
instructions.
bid.
They were bound to give me the results of the financial bid also, my lords, privately, because the same details, because they have opened the bid, my lords, they ought to be available on the website as well.
No, since this matter is in the
This should
court.
go only to the, my lord, the successful
No,
bidder.
this is in the court, so
This
they
is
may not,
absurd proposition, my lord.
unless we say, that's a different matter.
Yes.
But do you have the instructions, how much is your bid?
My lords, I can seek instructions now, my
Get the instructions. If otherwise you do not compete, then matter.
My lords, can I address on this point, man? I mean, let him finish. I have submissions relating to that. My lords, let him finish and then I'll address your honor.
Yes.
I have nothing to say more. Only thing, my lord, when his bid is, my lord, rejected at the threshold, authority cannot go with his subsequent bid, because financial bid is the last one.
No, Mr. Goswami, why we are asking this question is that there is an order of this court
Right.
that he had some difficulty, whatever he had projected, whether.
Yes, yes.
No,
But
whatever he had projected that to avoid EMD or otherwise we are not on that issue.
Right.
He said that, because of the experience clause, the portal will not accept my bid.
Right.
Court, for the time being, accepted and said that you go for a physical submission. He did it. You accepted it. Thereafter, you rejected it again on the experience ground. That part we may have some reservation because that is the issue pending before us. We have not said anything. But so far as financial bids are concerned, you have opened it. It's in a
no, his bid is not.
No, not his bid. His bid, so far as his bid is concerned, we can have the instructions after hearing him. He wants to address also on this issue. And depend.
Only thing, his bid is not.
Do you have the instructions from your officer regarding the bids of the other two bidders?
Yes, sir.
You need not disclose immediately, but just have a look, have a preview to this. And if you have completed, we'll hear him and we'll. That's all?
Right now, that's.
Okay. That's enough.
My lord, as far as the submission goes, my lord, that I have not disclosed, my lord, the pre-bid, the query on my pre-bid, my lords, that's in para number 18 of my writ petition, my lord.
No,
At
we
page-
are not going into those
My lord.
questions. No need.
My lords, as rightly observed by my lordship, that page number 383, which says that I have completed certain works, my lord. If my lordships has page number 384,
Yes.
the last item, my lord, item
Yes.
number 10.
Yes.
Assam Gas Company Limited, the value is 1 crore 78 lakhs odd rupees, my lord. So there stands that I do not qualify on the work completion order because I don't have sufficient technical qualification and financial prowess, my lords. That is not correct, my lords. I am very well.
My lord, I have two judgments connected.
Yeah, I'll note down the judgments. Just hold on for a time.
Not now.
Just hold on after his completion. Or you see aside the judgments. Yes. Just Mr. Khanna, just a minute.
Yes, ma'am.
Yes. What are the judgments?
First one is, my lord, Michigan Navar, 2012 8 SSC, my lord. 216, 2012 8 SSC, 216, paragraph, my lord, 35. Second one is, my lord, 2020.
Paragraph 35.
35.
Only two conditions.
30, only some.
Only two conditions where courts may interfere.
Yes. Another is, my lord, 2022 6 SSC, 127, my lord.
22, 6 SCC.
127.
This is FCONS or what? FCONS.
No, NG project, my lord.
And NG is on a different context. It is after the amendment of the specific relief act.
2020 16 SCC.
2020.
16 S.
16 SSC, 489.
Silpi construction.
Silpi construction.
Yes.
489.
Silpi is paragraph 20.
20.
Okay. Okay, that's all.
My lords, as far as we are on judgment, my lords, there's a Calcutta Honorable
No,
Calcutta.
no, place the
My lord.
judgment later.
My lord.
Make a rejoinder.
Yes. So, my lords, I was on page number 384.
Yes.
Item 10, my lords.
Yes. Tata Motors, or Tata Cellular.
Tata Motors.
Tata Motors, which one?
AIR, my lord, SC, 2717, my lord.
Yeah, 19? 2000?
2022.
23.
Yes, my lord. AIR,
2023.
SC, 2717, paragraph 50.
2717.
Yes.
Tata Motors.
Yes.
Para?
Paragraph 52, my lord.
Okay. Yes. AGCL is more than almost 1.7
My lords,
crores.
I'll come to that. Page number, that is correct, my lords, more than 1 crore. And my lords, as far as the sophistication goes, that I am incapable, I am just a newcomer and so on and so forth, my lords may see item number 2, my lords. Or on page number 383.
Yes.
Supply, installation, testing, commission of security automation system of ALA Secretariat, my lords, these are not only hardware, they are very sophisticated software implementation. Also, these are bespoke software implementation along with hardware combination, my lords. Work value is 8 crores. Then, my lords, item number 6. My lords, the tender which they have come up with, my lords, is I'm not operating only a call center, my lords. This is a software enabled mass media implementation program through a call center as well, my lords. I have call centers, I have social media, and my lords, the details are in front of your lordship, my lords. I need not get it. Their stance is, for whatever reason, my lords, they have not been able to substantiate why are they so acrimonious towards me, and where have they gathered the data that I am not capable of implementing these work. Their submission notwithstanding, my lord. Then, my lords, the payment, the aspect of the payment which they say that I have escaped the EMD payment. My lords, it is the benefit which has been extended to me by virtue of the operation of a substantive law of the land. 50% is on record, my lords. There's an admission to that effect as well. On their criteria.
He himself has decided.
I have not decided anything.
That 50%, my lord, that he himself has decided.
Subject, my lords, this is my main prayer. Subject to the.
He's the employer and he's
Sir,
the my lord.
Sir, if you can extend the same courtesy to me, sir, please. I request.
Okay. Not that side. 50% EMD, okay.
50% EMD, my lords, is coming from substantive law. This is not to my discretion, my lords. I'm saying that these are the benefits which ought to have been extended to me at the very outset, my lord. The technical qualification criteria, my lords, at page number 345, which is annexure 6.
345.
345, my lord. My lords, there's another legible copy. If my lords may have page number 11 of their affidavit of this is IA Civil, my lords, 2684.
Same thing.
Same thing, my
It
lord.
doesn't matter. We can.
Right, my lord. Now, my lords may have the tender, my lord, at page 75. I'll just take a second, my lord, to get the relevant information. My lords may have page number 80. And these are conditions set by them. My lords, on the last date of hearing, my lords, I had submitted that this is not a conventional L1 mode of bidding, my lords. This is a QCBS tender as set by them. Now, the minute they indicate that this is a QCBS tender, my lords, there are certain guidelines which are prescribed on how the evaluation should be, my lords, and those are codified in the law, my lords. This will come from the GFR rules of 2017, my lords, as amended, as well as the Assam Procurement Public Procurement Services Act of 2017 and the rules read with me. Now, my lord, this is rule number 25 of the procurement rules, my lord. Subclause 7, my lord. Methods of evaluation and selection of consultancy proposal, which is applicable to this tender, my lord.
25.
Rule number 25, my lord, subclause 7. It reads, my lords, methods of evaluation and selection of consultancy proposal. Now, my lords, they themselves have said that this tender shall be evaluated as per the QCBS norm. Now, the QCBS norms are further elaborated thereunder, my lord. QCBS, I'll read, my lord, shall be used for procurement of consultancy service where quality of consultancy is of prime concern as expressed by the respondent number 2 as well, man. In QCBS, initially the quality of technical proposal shall be scored as per the criteria specified in the RFP. only those responsive proposals that have been obtained the minimum qualifying score in the technical evaluation as specified in the RFP shall be further considered. Agreed, my lord. After opening and scoring of financial proposals of the responsive technical qualified bids, my lords, who have obtained the prescribed minimum score, a combined score for both the quality and the cost aspect shall be arrived at. Lastly, my lords, the RFP shall specify the minimum qualifying score for the quality of technical proposals and also the relative weightage to be given to the quality and cost determined. My lords, I am saying that I am very happy to be subject to this. Please tell me, please disclose as to how you're going to evaluate me, my lords. And therefore, my lords, the GFR 2017 Rule 192 also applies to me. Same, almost the same, my lords. I'll tender a copy.
I think it's mentioned here.
My lords, it's at parity. Now, my lords, after I had put in the bids, my lords, after I had put in the bids, I had issued an email, my lord, which is at page number 300. It reads, my lords, form and manner of bid evaluation is the subject matter. By this email, my lords, I am specifically asking them that now that I have been allowed by the order of this honorable court to participate in the offline mode, my lord, before you technically or financially evaluate me, please disclose as to what norms will you evaluate me with. My lords, it's completely opaque. There is no transparency. There is only, my lords, there's only a resistance and inexplicable resistance. It is as if they have made up their minds as to who the successful bidder should be as well. And my lords, again, I will emphasize on one point, my lord, that even after successful extensions and corrigendums and so on and so forth, my lords, there were only 3 bids, only 3 bidders who participated, my lords. I'm the third one. And the default, my lords, I concede to the point that if there is a specific consent by the higher up authorities for the relevant ministry, my lords, if there are only 2 responsive bids, the tender has to be reissued. There is a mandatory requirement of 3 bidders to have a responsive technical bid. And my lords, I'll read the specific provision of law as well, which comes from the Assam Procurement Act of 2017. My lords, just allow me 10 seconds to reorganize. Rule number 2316, my lord. Of the rules.
Rules.
Of the rules, my lord.
Yes.
16.5, my lord. Right at the bottom of the page. The number of firms qualified in the technical evaluation should not generally be less than 3. If the number is less than 3 and it is considered necessary for the procuring entity to continue with the procurement process, reason shall be recorded in writing. My lords, nothing has been found on record. Now, my lords, I will read.
Qualified.
Because of the restrictive technical qualification, my lords, there is no participation. There is no wider participation. It hits the very provision for which the MSME Act was built, for the very purpose for which the policies are were notified, my lord. And they're failing to implement, my lord. I will go as far as, my lords, I've already submitted. So, my lords, the procurement policy, my lords, the section 13 of the policy 2021. Okay. This is page number 52, my lord. There are penal consequences to the department
Yes, you have shown.
for setting up a restrictive clause. And non-implementation of the MSME policy along with the procurement policy. Lastly, my lord, the respondent number 2 relied on page number 396 E. My lord, his submission directly hits the very foundation on which I stand on today. Saying that this is of no consequence, the provision shall not apply. My lord. And my lords, lastly, I'll just forward your lordships. At parity, my lord, there is a similar question which has been decided by the Honorable Calcutta High Court, my lord, single bench. I'll just give it.
Okay, and citation?
My lord, it's my lords, I don't have it. I don't have the citation. I have the Manu Patra citation, my lord. It's Manu WB.
The date of the judgment?
Date of the judgment is 7/7/2023, my lord. WPA number 12837 of
2023.
7/7/2023, my lords. WPA number 12837 of 2023, my lords. I have a convenience set, my lord. Exactly on point, my lord. On the implementation of the policy. And here, my lords, what had happened is the Honorable Calcutta High Court allowed the 25% rule to kick in, my lord. Where even if I am not the successful bidder, even after the technical relaxations are granted to me and so on and so forth, and my financial bid is not the lowest bid, even then, my lords, the 25% rule will ordinarily apply to me. And today I'm saying that on an assumption because today I don't know what the outcome of that financial bid evaluation is.
Yes.
My lord.
That's all? Okay.
Right.
Yes. Yeah, the financial bids which
Yes,
have been opened
that
are there.
First,
Can you,
this has something, otherwise. it's good.
okay. Heard. Sri K. Khanna Learned Counsel for the petitioner. Also heard Sri B. Goswami Learned Additional AG. Assam. Full stop. Sri M. Chettiar Learned State Council. Assisting the Learned AAG has also furnished the records in original. The hearing is concluded, judgment is reserved. Okay,
Right.
we'll consider.
My lords, do I still need to come back with a?
See, so far as we thought that you'd, that would be relevant, but if you are held to be eligible in the technical responsive test, then even if you are not the highest bidder, 25% you will get. So that is not the issue, whether you're the highest bidder.
Obliged.
Good Jamila No, তাতে দি দিয়ে।
Your lordship, matter pertains to the non-payment of public sale bill made. On last occasion, the 14/8/2024, this court asking for instruction for the case of
Notice was issued.
notice was issued.
1480. Any instructions?
Lordship, their name found in the list, a new list has been prepared, lordship. But kindly please start, lord.
30.
Please. Representation which has been annexed by petitioner is not his own, lord.
Who is the petitioner here? Atul Basin.
Atul Basin. Then representation is submitted by one Mohammed Muslim Ali. No, lordship, I may be some another different case was already I have filed, but maybe it may be mistakenly annexed. So I may that has been given as 26/2024. The body of the petition, lordship, paragraph 8.
Yes.
The same case has been filed by the by
You file an additional affidavit. This is a different.
and my lord,
You take instructions otherwise.
Lord.
Dehearse this Annexure 6.
Lord.
You take instruction on the other parts and
Lord.
she'll file an additional affidavit and bring the original, the annexure pertaining to this case on record. Okay. Ms. R.B. Bora, Learned Standing Council, BTC. Praise for and is granted. Praise for submits that instructions are yet to be received. Full stop. C, however, points out that Annexure 6, which is a representation, does not pertain to the petitioner but some other entity. Full stop para. Ms. A. Buzarbura, Learned Counsel for the petitioner, submits that due to inadvertence, comma, the wrong document has been annexed. Full stop. C, prays for and is granted 3 weeks time to file an affidavit to clarify the issue.
Yes.
Full stop. In the meantime, comma, the Learned Counsel for the Standing Counsel for the BTC may also file the affidavit in opposition. Item 12, yes, what is this? Contempt matter.
Well, please, your lordship, in last occasion, we have taken time to file affidavit, but we could not file that affidavit because we could not obtain the signature of the petitioner.
You will grant some more time.
Lordship, we have already passed the speaking order. Contempt was filed.
Where is the speaking order?
Lordship, our affidavit we have filed on 27/8/2020.
By Rongpi,
Lordship,
Dancing Rongpi.
Lordship.
Page,
Page 54. 50.
in the
53,
additional
53.
affidavit.
Yes, sir.
In the additional affidavit.
Yes, sir. Additional.
14/8/2024.
27/8.
No, the order.
Oh, yes.
14/8.
Yes, 40.
This is issued by the Joint Secretary Kam Kala.
Yes.
Madam, you need to, if you are aggrieved by this, you have to challenge this.
Lordship, actually in the speaking order, they have stated that the revenue villages name Nahurtan Block 1 and Nahurtan NC are two different villages. They have stated like that. But in earlier notification, 24 March 2022, one notification was there. We have challenged that notification. It was clearly mentioned Nahurtan, not Nahurtan NC, Lordship. And in
Mr.
their
Chutia?
affidavit,
They are seeking time to file rejoinder, which
Right,
they
they
had
file a
done on the last occasion, but your colleague has pointed out, that on 14/8/2024, a speaking order has already been passed. So
And
prior,
my lord, the petitioner has already approached the my lord civil court. civil court passed us out. That was not earlier disclosed to the Supreme Court, my lord. And we have already passed the order, my lord. They can assail the order by way of after repetition, not in the contempt of my lord.
Madam, you need to, if you're aggrieved by this, need to challenge this. This is a recent order of 14/8/2024. Your filing of rejoinder is only drag this matter, will not get anything.
Well,
You will give you liberty to challenge this, okay? What is your name?
KLR Yanthan.
You're on record.
Yes, Lord.
Heard Miss KLR Yanthan, learned counsel for the petitioner, who submits that on the last occasion, though time was taken to file rejoinder, comma, the same could not be done due to some inconvenience of the petitioner. Where Sri J. Chutia, learned counsel, learned standing counsel, KAAC, has however submitted that in no, not KAC. J. Chutia, learned for the sole respondent, has submitted that the order dated 9/5/2022 passed in WPC 2828 of 2022, which is the subject matter of this contempt petition, has been complied with. And in this regard, comma, he has referred to the additional affidavit filed on 27/8/2024, full stop. In the said additional affidavit, comma, a speaking order dated 14/8/2024 has been annexed, full stop. It is the submission of the learned counsel for the sole respondent that if at all the petitioner is aggrieved, comma, a challenge in accordance with law has to be made, and the question of any deliberate or willful disobedience will not be will not arise. Full stop. Para. Considering the above, no, para. This court has the learned counsel for the petitioner has, however, submitted that the order dated 14/8/2024 is erroneous, as irrelevant factors have been taken into consideration. Full stop. Para. Upon hearing, comma, this court is of the opinion that if the petitioner is aggrieved by the speaking order dated 14/8/2024, comma, the same has to be challenged in the manner prescribed in law. Full stop. When law and their law in law. Full stop. Since the said order has been said to be passed pursuant to the order dated 9/5/2022, comma, the prima facie, comma, the aspect of willful and deliberate disobedience will not arise. Full stop. Para. In view of the above, comma, the contempt petition is closed. However, with liberty to the petitioner to challenge the speaking order in accordance with law, if so advised. Item 13.
Here, my lord, I was required to, I'm required to obtain the instruction whether what has happened to the proposal sent to finance. But my information is that it is still pending with the.
May it please your lordship, since 1 year, your lordship, more than a year,
Correct.
lordship. I don't know why it's lingering, your lordship, and the person is suffering a lot, lordship. He's a dialysis patient, your lordship. It's more than a year, your lordship had passed an order on 28/3/2023. Since day by day, they have taken time. It was in finance department. It was
Finance officers are party here or what?
Finance is not a.
Officers are not party.
Not a. I asked them, my lord, they said that it is still from the finance, it is not.
My lord, in the order, it has been directed to PWD department, your lordship, public work department, to release the balance of amount of rupees 30,13,755, your lordship. And within the period of 45 days from
This
total
was
failing,
listed
your
last on 21/8. Today is what?
Today's
Nine.
10,
10th, your lord.
10.
10th.
It was in the
So
month
no-
of.
So not, this is not fair and this is not the proper.
That's. I do it.
The matters have to come to a finality. Now it has reached a finality. It has to be complied with, implemented.
But my lord, without the concurrence of the finance, my lord, it is difficult on their part of.
Which department is this? Public Works?
Yes, your lordship.
The financial secretary, but that is difficult.
In the original case, was finance a party? No.
No, your lordship. No, your lordship.
You appear for whom? 1, 2, and 3. Mr. Nath?
Lord, for the no, yeah.
All the respondents.
Lord. Lord, I spoke to them, I told them that sent the reminder and all. Because they
You
got it.
produce those.
Yes, that I have,
Where?
the letters which were forwarded to the finance,
Yes.
those were, I placed.
Do you have copies?
Aye.
Well.
First,
One is to 7/4.
2007-4 and then will the checklist, from the department, PWD department, particularly at page 3, signature is there. The senior finance officer has already signed. It was sent to the finance.
26/6.
Yes, in the month of June.
Heard Miss S. Walk, learned counsel for the petitioner. Also heard Sri D. Nath, learned counsel for the respondents. Full stop. On the last occasion, that is 21/8/2024, comma, Sri Nath, the learned counsel for the respondents was directed to seek instructions. Full stop. Para. The learned counsel for the respondent has submitted that the fund proposal connected with the order dated 28/3/2023 passed in WPC 381 of 2014 has been resubmitted to the Full stop. The learned counsel has also placed on record a checklist pertaining to the amount to be released, which was issued by the Special Commissioner and Special Secretary, PWD, on 26/6/2024. Full stop. The writ petition in which the concerned order dated 28/3/2023 is of a writ petition of the year 2014. Full stop. In view of the above, comma, let further instructions be obtained with regard to the progress achieved in the matter, including the steps taken by the Finance Department pursuant to the checklist issued by the Public Works Department. Fourth up, list on,
So to make, give us six.
we'll give you time, list on today's 10th, we'll have it on, we'll have it on 25th, 27th.
Sure.
25th, 27th is too long.
Apply.
You have copies of this?
I'll make.
Get the instructions, this is
I'll-
not,
Notify.
man is suffering and matter has attained finality.
I'll make copy.
Okay, you know, copy one ID card. We'll make copies, don't worry.
Sure.
Okay, next. Fourteen matter, iman purana matter আছে।
Lordship, may kindly pass over the matter for the time being, sir.
Timing at 3:30. Who is the senior?
Mr. M.K. Shan. He's on lecture in another court.
Mr. Goswami, you are appearing.
Yes, my lord, for respondent number 2 and 5.
What is the matter?
My lord, it is basically a contractual dispute between two parties, private parties. And
who is
we-
for the Union of India? Which segment is involved? Railways?
No, my lord, it is between, one of the respondent is Brahmaputra Cracker and Polymer Limited. Gas
Okay,
Cracker.
okay.
And I am representing 2 and 5 Engineering Projects India Limited,
EPIL,
EPI.
okay.
My lord, should I go ahead, my lord?
No, let his senior come, but 14 matter would not like to defer this kind of matters.
Yes, my
You
lord.
just can give an overview without causing any prejudice.
Yes, my
We'll hear the petitioner first, obviously. What is the issue involved?
My lord, it so happened that BCPL is the main
You,
owner.
and he is, who is he?
He is subcontractor, my lord. He is not even a contractor of API. So main content.
You are the owner.
No, my
Who,
lord.
who floated the tender?
I procured the tender.
No, who floated the tender?
My lord.
Who
Floated the first, it was floated by BCPL.
BCPL is the owner.
Yes, my lord. Then we got the tender, Engineering Projects India Limited.
You bidded.
Yes. And under the terms of contract, we can further sublet the work, and we subletted it to NEPS. NEPS is respondent number 4.
Sublet to R4.
Yes, my
What
lord.
is R4? Who is R4?
It is NEPS India Private Limited.
NEPS.
NEFFS.
NEFFS.
Yes, my lord. And thereafter, my lord,
This is regarding what work?
it is relating to project at Lepatkata in Dibrugarh.
No, what
Construction work. civil
Construction, okay.
Yes, sir.
You were the successful bidder, work allotted to you, you sublet it to
NEPS.
NEPS. Then
Yes.
what happened?
And NEPS has given it to the petitioner.
My God. You were allowed to give a sublet, you were allowed to sublet to a third party.
Yes, my lord.
But NEPS was NEPS allowed?
NEPS should have done work, but anyway, that is not in dispute now, my lord. Now, the subcontractor has, as a petitioner, has brought this writ petition. May I pray before my lord to look into the prayer of this writ petition?
Okay.
My lord, it is in page 11.
11. Yes.
In the premises, may I read, my lord?
Yes, yes.
In the premises aforesaid, your lordship, humble petitioner, pray that the honorable court would be gracious enough to call for the records and issue a rule calling upon the respondent to show cause as to why a writ should not be issued directing respondent number 2-1 to release the bill amounting to 1,81,000 directly to the petitioner by respondent number 2. Direct respondent number 3 to give a detailed report of the pending bills to respondent number 2. So, my lord, it is a money suit, basically.
Very much.
have it put, my lord.
We have just trying to have an idea. We have not heard the matter. We'll hear you. Then,
My lord, there is admission. Petitioner admitted that. May I request my lord to go to page 5.
no, you just give an overview.
Yes, my lord, they have admitted that they are the contractor for the respondent number 4. Their only contention is that once or twice we have made direct payment to them. So they are trying to establish a relationship. My lord, number 1. Number 2 is that we do not have privity with the petitioner. And my lord, there is no admitted liability. This 1,81 lakhs is not an admitted liability, my lord. And that has changed from time to time with petitioners later only. That only also I can show, my lord. So it is a disputed question of fact, my lord. I do not have privity, my lord, first. Second is that it is not an admitted liability and the figures are also changing, my lord.
okay, Mr. Sharma.
In this regard, my lord, on in IA number 1695, so the submission of the party, particularly Attorney Brother has submitted the figures to my lord amicable. That was my lord, talking is still going on, as I have been intimated by my client. And so far the defense,
IA for what? IA was for?
I, my lord, 1695.
It was for what?
Perhaps this for my lord. The order dated my lord 15/5/2024.
15.3. There is only one order, 13/12/2021.
My lord, IA number, my lord, 1695.
Yes, 1695. There is only one order, 13/12/2021.
Next, my lord, I have, my lord, downloaded it on 15/5/2024.
Maybe in the writ petition. 15.3?
15/5/24.
It's in the, okay. Yeah, I have, I would
Alright,
decide my
that's
Tate Maribole, other three this. Can I confirm? Into higher order, yeah, WBC to this.
My lord, so for
Yes.
talking in between the parties, man. So far the liabilities are concerned, that is still going on. Even here, my lord, evening yesterday, my lord, yesterday evening, I was intimated. And that is the submission to my Attorney Brother on the last occasion on 15/5/2024.
Now, if you settle the matter outside the court, we are more,
We are
we'll
ready,
be more than happy.
My lord, with
14th of-
apology, I have to intervene. My lord, there might be settlement between respondent number 4 and EPIL. But there does not arises any question of settlement between the petitioner and respondent EPIL. My lord, there is one more fact. There is a, which has not come into record, there is a DRT order. Because respondent number 4 is a defaulter. And now DRT has said that any payment to respondent number 4
We'll go
has
to them
has
first.
to be given to Punjab National Bank so and so account. And even there in that order, they have specifically stated that our money from BCPL, EPL's money should also come to that account, PNB account. But that we challenge it at DRAT, and DRAT has quashed that part of the order. That BCPL money can come directly to EPIL, but EPIL has to give it to PNB.
Whatever the situation, it may be, my lord. On 14th of September, local order is there, man. 14th of September. My client is under the respondent number 4 is also willing.
No, Mr. Sharma,
My-
all said and done, even if you enter into an agreement and there is an endorsement by the Lok Adalat, that cannot override the orders of the tribunal, which
Well,
has
That will, my lord,
which
come
has put a
later.
kind of a lien over any amount which
That will,
may
my
come
lord,
to you.
Because, my lord, against me also, my lord, DRT case is pending. So public money is, my lord, there, involved is there. But so far our work is, my lord, concerned. It was not denied by the authorities that we have not carried out any work. Let the matter be settle first outside the.
No, even if you hold that you are entitled,
Right.
the money will go directly to the DRT.
My lord,
My lord, second thing is that why it would be given to Lok Adalat, my lord, at their request, because I don't have any privity. Number one, writ petition itself is not maintainable, my lord.
that is also not.
R4 has appeared.
My lord,
R4 has appeared.
Appeared, right?
Who is the counsel?
P. Chakraborty,
Huh?
NSP Chakraborty.
Mm.
NSP Chakraborty was Papia Chakraborty.
Is she there or not?
No. Hello.
14 matter, we don't want to postpone for a okay.
Some 14th of September, it was a local. If you lost it, please to put the matter here.
Okay, we'll have it on Tuesday next. You take a
My lord,
chance.
I will
We
take
don't. I don't see any
my lord,
positive.
I have some difficulty, my lord. I will
Thursday.
be, my lord, I see the date, my lord. I won't be there from
If not on 17, we can have on 19th. 19th, Mr. Goswami.
my lord. If it is on 20th, it would be convenient.
Friday.
Friday, my lord, but I don't know. It is a hearing matter, my lord.
Friday, you can try.
Yes, my lord.
Friday. Okay. Though this matter is of the year 2014, comma, Shri Sharma, the learned counsel for the petitioner, has submitted that there is a scope for amicable settlement in the ensuing Lok Adalat scheduled on 14th of September. Full stop. Para. Also heard Sri P. Goswami, learned counsel for the S1 number
2 and 5.
2 and 5 dash EPIL. Para. In view of the above, comma, let this matter be placed before the Lok Adalat scheduled on so and so. If there is, if an amicable settlement is not arrived at, comma, matter to be listed for consideration on 20 September.
All right. Another, if my brother as well as I will intimate my client, the notice in that figure may not be. So for
Notice, obviously you are making a consent of the parties. Will your client be available?
My lord,
Your client has to
I
come.
would inform them, my lord. I do not have it.
Since in view of the order to place this matter before the Lok Adalat has been done in presence of the learned counsel for the contesting parties, comma, separate notices are not required to be issued, and the learned counsel will intimate their respective clients to be present.
Yes.
All right.
Respective clients to be present through their authorized representatives.
All right.
You can take this back, DRT order, next occasion.
Yes, that's fine.
Yes, motion.
Here only, my lord, the change of name of the company, my lord, that may be accorded, my lord. No. Petition number 3, my lord. From Ruchi Soya to Patanjali Food Limited. That is the company, my lord. Mr. Order is there.
Yes, what is this, Mr. Gogoi?
My lord, he was asked to, my lord, to produce the company authority order, my lord.
Lordship, this honorable court has directed me to take instruction on page 32.
No, so far as the I is concerned.
I am, my lord, name change only, my lord.
No, the transfer of their name.
Company's name has been changed, my lord.
Ruchi Soya to Patanjali Foods.
A public limited company.
It is done through the ROC.
That is that page 18, my lord, yes.
Page 18, okay. And Ruchi Shah is Rasma number?
3, no, petition number 3. Petition number 3, madam.
Oh, this is that matter
Yes.
Lord,
where
Demarage.
Demarage and water.
Demarage.
Demarage.
Okay. What is your instruction?
Lordship, my instruction that the GM is the appellate authority where they can go for the appeal. As per the annexer, your Lordship, I have communicated to annexer 14, annexer page 14, your Lordship.
No, we asked you that
It is
you had issued a WT message of 27/1/2015.
Yeah, that is the answer have been given in page 7 of C of my affidavit in reply.
When did you
Affidavit
file
of page 7 C, paragraph C.
of your reply affidavit?
Yes, yes. It has been mentioned here, Lordship, it is seen that some parties total applied for waiver. After thorough examination, DRM Lamding has rejected the request. Then, on appeal, then they went for the appeal, CCM and Railway also rejected the request. However, if the parties are not satisfied, there is a provision for appeal against the order of the waiver as per
No,
paragraph.
that is not a decision-making process. We said what was considered, what was the relevant consideration, while which led to passing of the WT on 27/1/2015.
That order that I communicated since it is purely on the landing, your Lordship, the better.
No, see, you just will not write a single order that rejected. You will have some factors which you have considered. We want to know what are the relevant. If you find that you have taken into consideration relevant factors, we may not enter further.
My humble prayer before this honorable court, page 14 of
Of?
our affidavit.
14/14.
1/4.
Yes.
That is the circular, your Lordship. Now they have went to the CCM. As per the provision of 1104, annexer 3, page 13 is the circular and page 14 is the circular where they can go for the GM. And they have to be go within the 30 days.
Yes.
Now, since it has been around 9 years, they appeal for 9 years. If they approach for the GM, then GM can take a decision, your Lordship, after being rejection of the DRM or CCM. That is a
Dr.
problem.
Gogoi, this remanding a matter after so many years will not serve the purpose. We want to only oversee whether the decision-making process is based on the relevant factors. That is all.
That.
You bring the instructions or that file, how the decision was arrived at. See, you have on the last occasion, if you remember correctly,
Lord.
you have said that the order was passed because it took 188 hours. And somebody had 199 hours.
Lord.
And the racks were placed in a vacant line.
Lord.
And further, the delay in unloading has a cascading effect. You just want to take a call how the decision to issue the WT message was arrived at. That is all. We allow the IA. Okay.
Yes.
Heard Sri G.N. Sehol, Alan Senior Counsel, assisted by Ms. For the petition, for the applicant / petitioner number
3.
By this application, comma, a change of name of the petition number of the applicant is sought for. It is submitted that the petition number 3 was named as Ruchi Soya Sailaba, huh? Full stop. Ruchi Soya Industries Sports Sailaba. However, wide a certificate issued by the Registrar of Companies dated
24th of June 2022.
Dated 24th of June 2022, comma, the name of the respondent, name of the petition number 3 has been changed to Patanjali Foods Limited. Full stop. This is para. Also heard Dr. B.N. Gogoi Leonard, Standing Counsel, Railways, para. This court has examined the certificate issued by the ROC, comma, Mumbai, indicating the change of names. Full stop. Dr. Gogoi submits that he does not have serious objection to the application, to the prayer made in this application. Full stop. Para. After consideration, comma, the application is allowed and the name of the petition number 3 is allowed to be replaced by the new name, namely Patanjali Foods Limited. So I accordingly stand disposed of. In the main writ petition, you write, this court has allowed IA 2780/2024 today, that is so and so, whereby the name of the petition number 3 has been permitted to be permitted to be changed. Full stop. Such change has been allowed in view of the change of the name of the company through a certificate issued by the Registrar of Companies, comma, Mumbai, dated so and so. Para. Learned counsel for the petitioner is accordingly required to file an amended cost title within a period of 3 days from today. Full stop. Para. Dr. Gogoi, the learned standing counsel, Railways, is appraised for and is granted further 10 days time to obtain necessary instructions regarding the decision-making process towards issue of the WT message dated 27/1/2015. Okay.
Item 16.
Now, Peter Lordship, the last occasion we have taken time for obtaining instruction, your Lordship. But press instruction we have not received, your Lordship. Just kindly, maybe get to obtain
Madam, you have for respond number
Section number 1, 3, and 5, your Lordship.
3 and 5 have filed affidavit already.
Lordship.
Why fresh instructions are necessary?
The Lordship, the land, the market was shifted to the government land or not, Lordship?
12-15 matter. Mr. Sikdar, what do you say?
My lord, my client also want to file an additional affidavit.
9-year-old matter.
In fact, we have prepared and he is coming on witness day. Matter may taken up in the next week.
Okay. Sri A.R. Sikdar, learned counsel for the petitioners, submits that an additional affidavit would be filed, for which she prays for a week's time. Para. List after a week. Para. Ms. J. Bora, learned counsel appearing for the department, may also obtain the instructions by the next date.
I'm obliged.
18.
My lord, here the Employees Provident Fund Organization has filed an, my lord, review against the order passed by the appellate tribunal. The appellate tribunal, has, my lord, reduced the penalty, my lord.
Other side,
my lord,
who is to? Who is the beneficiary?
Escort Bank, in fact, Escort Bank, my lord, basically.
He is the beneficiary.
Escort Bank. My lord, yes, yes.
What are your?
The page 93 is the order, my lord, passed by the appellate office. My lord.
No further appeal is provided.
And after that, no further appeal. No further appeal. It is only for the.
What is it?
Well, a short question. If Lordship kindly come to page 94, I'll page
94.
Yes, 94. Page 11. My lord, the authority, my lord, has 14B has passed an order for damages under 14 capital B of the Employees Provident Fund Act. Against that, my lord, they have approached the appellate tribunal. That is, the relevant part is at page 94. Page 93 is the order. Relevant part. My lord, paragraph 6, page 94, lordship kindly come. Yes, our, there. Lordship got it, my lord.
Please read the whole.
In the case.
No, please read the entire order.
Entire order, right, madam. The present appeal is filed under 7I of the Employees Provident Fund Ministerial Provisions Act against the order dated 7/12/2012, past 14B and 7Q, hard at length. It is contended of the appellant establishment that since the day the appellant PF code, appellant established it following the provisions of the Act. Respondent passed impugn order dated 7/12/2012, a belated period of 6 years, March 2006 to March 2011, on the higher side, ignoring the case of so-and-so, upholding the law of the division bench of the High Court of Delhi, so-and-so. So the impugn order is liable to be set aside. It is further contended on behalf of the appellant establishment that appellant was establishment to cater to the needs of the agriculture and based on small industries, several industries not remitted loan amount to the appellant establishment, and on that account, appellant establishment faced severe financial crisis, and due to that, payment of salaries of several employees of the appellant establishment was also not paid in time. There was some delay in remittances, statutory dues, delayed payments, and so. Per contra and counsel, the respondent EPF is meant to provide social security to the downtrodden section of the society at the time of the retirement, death, during service, medical treatment, etc. The EPF Act is a social welfare legislation which cannot be done away with a strict adherence to the provisions of the mandatory. Under this Act, the employer is duty bound to make provident fund contributions on time, and in case and default, the employer is liable to pay damages. Any delay in payment of amount of damages, Section 6 EPF Act causes loss to the beneficiaries of the scheme. Thus, the damage that is sought to be recovered from the employer is for the purpose of indemnifying the beneficiary loss that they have suffered. On merit, it is contended on behalf of the respondent that as per the record, appellant establishment has been defaulting in terms of delayed remittances. Appellant was duly afforded opportunities to representation at the time of passing the impugn order of respondent as per the guidelines set by the Honorable Supreme Court in Organic Chemicals Limited. So, habitual defaulter such as appellant establishment cannot be allowed to claim any benefit of leniency. It is further contended on behalf of the respondent pass the impugn order by following the provisions of law, so appeal is dismissed, liable to dismiss. In the case titled Roma so-and-so versus so-and-so, it has been held by the Honorable High Court of Delhi that up to 26/9/2008, the earlier table continues to govern the assessment, which included the element of interest under Section 7Q of the Act shall prevail, and from 26/9/2008 onwards, damages and interest are segregated. In the case in hand, some of the period assessment is before 26/9/2008, so the respondent was supposed to assess the dues on the basis of earlier table, which included element of interest under 7Q Act. Admittedly, respondent passed the impugn order not on the basis of earlier table, continues to govern the assessment. Respondent calculates the dues applying the maximum rate of 17%, 22%, 27%, 37%. Further, the respondent already assessed the separately interest under 7Q of the Act. So the respondent was duty bound to apply rates at 5%, 10%, 14%, 15%, and 25%. As the respondent not carried out its obligation within the declared line, so the impugn order respondent is to go. It is noted that the respondent dealt with the mitigating circumstances as the appellant so. In the case, keeping in view of the circumstances above, the tribunal reached the firm opinion that the interest of justice be met, imposing 60% of the assessed damages on the appellant establishment along with entire assessed interest In terms of the above, the present appeal is allowed, the impugned order is set aside, amount deposited appellant on the basis so and so. My lord will kindly come to page 34. The order which was challenged, 34, I'll take your lordship the relevant
Who was
part.
the appellant here?
My lord,
Who was the appellant here?
appellant before the appellate tribunal,
The bank was the
the
appellant.
appellant,
The appeal was allowed.
appeal was allowed. Against that we have come. My lord will kindly come to page 36 now. The tribunal has held that we have calculated rate in a different manual, page 36 down below.
Yes.
After hearing the parties, page 36 down below.
Yes.
And whereas the period for which damages is to be levied pertains to period preceding notification dated 26/8/19. That was the notification which the rate was amended, which amended the rate of damages. Take the rates laid down under pre-amended rate, paragraph 32A, the Employees Provident Fund Scheme 1950, which provides for recovery of penalty at the rate of 17% for period less than 2 months, 22% per annum for a default 2 months and above, but less than 4 months, 27% per annum for default for 4 months and above, but less than 6 months, and 37% for default so and so, and more than and more for calculation of the quantum penal damages. For defaults after notification dated 6/19, I take the following rate: 5% per annum default and 10% and 15%. So, and under the provisions of the Act, the rate has been. My lord will kindly take up the scheme, my lord, the Employees Provident Fund scheme. My lord, the scheme says they provide the.
Yes, what?
For start my senior lordship, because there is a party, tribunal is a respondent number 1. I am respondent number 2 for start back. Just before my engagement, but the other set of counsel here. I have to file lordship, I have to collect. But the problem is lordship, all the start back matter lordship, Learned Advocate General taking up and all matters are part in the single judge of Honorable Court, Eddie Chowdhury.
That is
for some conclusion, because if there is any liability of bank lordship already know the condition of the bank lordship. Either it will revive or it will go for conclusion for liquidation. That part lordship already considering lordship, any liability, any matter lordship, everything.
No, maybe we not, but my lord,
But
if it goes like that in liquidation, and goes with this order, my lord, we'll get the lesser amount. That the lordship will have to determine this. Because that's the thing.
But who otherwise appears for the Escort Bank presently?
Escort Bank I am appearing. But if there is a respondent number 2 is the tribunal lordship.
Which tribunal?
Appellate tribunal against that is the court, my lord.
Appellate tribunal, we are certiorari jurisdiction, we are not too much. That's a formal party.
My only prayer, lordship, if any liability question is there,
well, it will be determined by lordship, my lord, here.
Those matters, some provident fund matter also there, but because ultimately everything is sum up for liability for bank. That part.
And then, my lord, the appellate has reduced it, which power is vested on the my lord, EPF trust, my lord. The appellate tribunal has no power to reduce the amount, my lord. That is the thing. There is no power. And the reducing is made on the basis of upon an objective satisfaction, my lord, that it is a Sikh establishment.
Now, are you prepared with the matter or not?
I am not prepared. And only part of the.
Do you have the brief or not?
No, lordship. I am just after 2073 case was.
You please help him with a brief. But we are not going to adjourn the matter because of the pendency of those matters.
Yes.
We'll have this on
lordship, if
on Tuesday next. Not day after tomorrow, Tuesday next.
Let it be Thursday, my lord.
Thursday next.
Thursday.
But not this Thursday, next Thursday. Okay? You can get a photocopy, you can get a certificate, you can get a copy from your learned senior colleague. Okay? Those three, pick your all. Oh, no.
Okay. Next week, sir. Oh,
19th.
17th, my lord.
17th Tuesday with 17th cannot be 17th is Tuesday we had said 17 you said you have a problem. Yes, madam, what matter do you
Thursday.
have sitting on the back, Mr. Decker?
Thursday.
Madam, you have some case? Mr. Decker, any matter? Okay. Oh.
Let it go on
Okay.
Thursday.
While
Next week, Thursday.
while Sri P.K. Roy Leonard Senior Council is present for the petitioners. What is your name?
AU.
Sri A.U. Ahmed Leonard Council has submitted that he would be appearing for the respondent number,
Respondent 2.
respondent number 2, which was earlier represented by another set of council, full stop. He prays for and is granted some time to reconstruct the brief para list on request list on 17th. Is it okay?
Thursday. 19th, my lord. Let it.
Whichever did 19th.
19th.